So, welcome to the rapid revision round for the Indian Penal Code. And in this session for today, we are going to have the discussion on the basic pointers with respect to the Indian Penal Code. So, let us see how many of you had joined this particular session. So, as with respect to the Indian Penal Code, specifically, we are talking about the Delhi Judicial Services. So, in the DGS exam, apparently 15 to 20 questions are there from the Indian Penal Code, and this is again a very, very important law which is going to decide that whether you will be able to crack prelims or not. So, in this session on YouTube today, we will be having the discussion that what can be the important questions with respect to the IPC. The session will be divided in two segments. One will be taken up today, and the second will be there tomorrow. We'll try to take up the basic things today, and the next area of discussion will be taken up by the tomorrow session. So let us start with the session for the rapid revision round of Indian Penal Code. I hope all of you, those who are there in the session, have already gone through with the conceptual clarities of the IPC, and only then you will be able to crack that what kind of questions can be there from the this prelims point of view. So if everyone is ready, and you can please mention in the chat box that whether we should start or we should wait for 1 to 2 minutes. You can please mention. Yes, very good afternoon, Anika. Very good afternoon, Tanya. Very good afternoon. How many of you have already done with the Indian Penal Code? You also please mention. Had you done it yourself with the conceptual clarities or not? Please mention. कितने लोगों ने अभी तक पढ़ लिया है? प्लीज बताएं. Because IPC के बिना तो कुछ भी नहीं होगा. IPC is very, very important. So just give me 30 seconds. I will be starting with the session in the next 30 seconds. Yes, so चलिए शुरू करते हैं आज का सेशन. दैट इज विद रिस्पेक्ट टू द इंडियन पेनल कोड. द फर्स्ट थिंग दैट यू हैव मस्ट हैव टू अंडरस्टैंड, ओके, दैट इन द IPC the basic questions with respect to its drafting, who had drafted it, when it is there, when it came into force, and all those basic things you people have to firstly analyze, and only then we will be shifting to the codified law. So as you people can see, the IPC was drafted by the first law commission. It was the first draft of the first law commission. It was chaired by Thomas Babington Macaulay. So Thomas Babington Macaulay was the person who was heading this first law commission. And apart from that, this law commission was established in the year 1834. Law commission was established in the year 1834. It was headed by Lord Macaulay, was the chairman, and it was having 3 other members. So you people just see that who are the other 3 members in the concerned first law commission, whereby the IPC was being drafted. So it was J.M. MacLeod, J.W. Anderson, as well as it is F. Millett. So these 3 persons are there who were the members along with Lord Macaulay. Lord Macaulay was the chairman of the first law commission, and thereby they drafted this particular Indian Penal Code. Now, this Penal Code was enacted on 1st of January 1860. It was drafted on 1st of January 1860, but there were certain amendments which were being done by Ben Peacock, who was the first Chief Justice of the Calcutta High Court, the then Chief Justice of the Calcutta High Court. So Ben Peacock had gone through with many amendments and revisions in the code, which is being drafted by these first law commission members and the chairman. And the next thing which you people have to understand that okay, on which date IPC was there and it came into force and when it is started and commenced. So it is 1st of January 1862, which is the date on which the IPC commenced, and the day on which the assent was given by the Imperial Legislative Council. It is of 6th of October 1860. So these are the basic dates you people have to read, and as well as you have to retain at the time of the examination. Now let us see that what other things can be there. Basic things, you know, the basic things are there, like how many chapters are there in the IPC. So 23 chapters are there. Along with that, how many sections are there? So 511 sections are there in the IPC, from which provision the IPC draft gets its constitutional validity. So there is Article number 13, Clause number 1 of the Indian Constitution, as well as Article number 372 of the Indian Constitution. Both of these constitutional provisions are giving the validity to the pre-constitutional laws, and IPC is one of the pre-constitutional law. Now, the next thing which you people have to understand that who is the father of the modern Indian modern legal education. It is a question of a general awareness, but yes, you must know it. That is Dr. Neelakanta Ramakrishna Medva Menon is generally called as the father of the Indian modern legal education. So though it is not directly associated with the IPC, but yes, with respect to the current affairs, such kind of questions, or with respect to the legal knowledge, such question comes in the exam. Now, with respect to the definitions of crime, though it is not very important that you have to understand that who has given which definition with respect to the crime, offense, etc. But there are certain persons whose definitions are very important, and Blackstone has defined that crime is a violation of the public rights. Stephens has defined that crime is a violation of the public right. Bentham has also given a definition of the offenses, that offense are whatever the legislature has prohibited for a good and bad reasons. Stephens has given the judgment with respect to this, like crime is an act forbidden by law, and it is at the same time revolting the moral sentiments of the society. So these definitions usually come in the prelims exam. So that who had given this particular definition, you people can take a screenshot also of this particular slide, so that whenever you are revising the IPC, you may understand that which concerned eminent jurist or which person has given which judgment. So as Austin has given a defined definition to the point that a wrong which persuaded at the discretion of the injured party and his representative is a civil injury, and a wrong which persuaded by the sovereign is called as a crime. Miller has also given a definition. That is, Miller has given a definition to a crime that to be the commission or omission of an act which the law forbids under a pain for punishment to be imposed by state by proceeding in its own name. So these are the basic definitions. I hope you people have taken the screenshot of this. Or Kenny has also given a judgment. Let us go for that also. That is, crimes are the wrong whose sanction is punitive and is no way remissible by the private person, by remissible by the crown alone, and if remissible at all. So just have a basic overview with respect to these definitions given by the different eminent jurists, like Blackstone has given the judge this definition, Stephens has given, Bentham has given. Now, apart from that, there is a certain legal maxims also which you people have to see. Like in IPC, there are a lot of legal maxims which usually comes. So the first legal maxim is there on your screen, that is nullum criminum sine lega nulla pune sine lega. So it is, the meaning is that there must not be a crime or punishment except in accordance with the predetermined law. So if any legal maxim is there, you people must have to take care of those legal maxims also, because though it is directly associated with your Indian Penal Code itself. So because the maxims, legal maxims are there in the exam. People must have to take care of that. Now, there are some basic terms like what is mala prohibitia. Like mala prohibitia generally means something which is prohibited by law. And after that, the basic things like who has given the maxim, that is actus reus non facitrium nisi mensitria. So this maxim was given by Coke. Okay, this maxim was given by Cook. So after this, let us come to some other pointers that are the introductory pointers with respect to the Indian Penal Code. That is, what are the leading cases on the concept of mens rea or mistake of fact, we can say. So it is R versus Prince. You all people might be aware of this particular judgment. That is a case on a strict liability, R versus Prince, where a person has taken away a minor and thereafter he stated that I was not aware of the age of that minor girl. But the court stated that though you have no direct intention to kidnap, but yes, because you have taken a person out of the lawful guardianship, you are liable for that. So R versus Prince is a leading case on the concept of mistake of fact in mens rea. There is another case which is related to the mens rea, that is Nathulal versus State of Madhya Pradesh. Again, the concept of mens rea is taken up in this particular judgment also. What kind of question comes in the DGS? That is, which case is related to mens rea or strict liability? So these basic cases which I am telling you people, these are directly associated with the concept of mens rea. There is another case, that is Ranjit D. Udeshi versus State of Maharashtra 1964. It is also related to the same point, that whether for the act of section 192 of the IPC, that is obscenity is there in section 19 section 292 of the IPC. So where if a person sell out any obscene object is there, that whether that person should be liable even if there is no mens rea, the answer is given that it is not necessary to show his purpose or awareness of the obscene material. The person should be held liable for this offense of section 292. Another important case, that's generally the introductory area with respect to the IPC, that is R versus Tolson, where a person has get into the second marriage. The lady has get into the second marriage, and thereafter her ex-husband came back, and whether she will be liable for the offense of bigamy or not. The court stated that no, she will not be liable, and the defense of mistake was being given to Mrs. Tolson. Another important case, Shiraz versus D. Ratze, a very very important case with respect to the concept of strict liability. That it usually comes that which is a case of strict liability. So it is Shiraz versus D. Ratze. The case was being decided by different judges, but Lord Justice Wright has given this particular pointer, that there is a presumption that mens rea and evil intention or knowledge of the wrongfulness of the act is a very essential ingredient of any offense, but that presumption is liable to be displaced either by words or words of the statute creating the offense, or by the subject matter with which it deals. So this judgment, that is Shiraz versus D. Ratzin, is important for you people. It is important. What kind of question comes, that which case is related with the concept of strict liability, or in which case it is stated that even without mens rea a person can be held liable. So this is that the judgment, that is Shiraz versus D. Ratzin. I hope you people have gone through with all of these cases. People can please mention in the comments. It is only the introduction. Waiting for the other candidates who will be joining in the meanwhile. Then another important thing which usually comes, that ignorance of law is no excuse. So the main important case on this point, that is State of Maharashtra versus Mayer Hans George. It is MH George, by which name you call it, this particular judgment, that is leading case on the ignorance of law is no excuse. In this case, a person, a German national, was traveling from one place to another, and his plane was boarded from Manila and boarded towards Manila, and for the halt it was there in India, and he was having certain gold with him which he has not disclosed, and ultimately the foreign exchange authorities, that is the custom authorities, they arrested that person. The 34 kg gold was retained from that person, and then the person was prosecuted in India itself. There is another case related to the same point, that is Menzaria, that is Srinivas Malbarolia versus Emperor 1947. In this case also it is stated that Menzaria is a constituent of the crime, and without misery, generally a person will not be held liable unless and until it is a question of the strict liability. Okay, so such judgments are very important. Directly, whenever the question comes with respect to the IPC, these judgments related to the mens rea, what is the maxim actus non facit reum, and the other related things, strict liability related issues, these usually come in the exam. So you just take care of these things. Now let us come to the main portion of the session for today, that is with respect to the Indian Penal Code. Let us start. And as IPC is there, what is the territorial extension of the IPC? The first thing which comes to us, what is the territorial extension of the IPC? Look, as Indian Penal Code is applicable to the whole of India, but as it is stated over here also, like before 31st of October 2019, it was not applicable to the state of Jammu and Kashmir, but yes, after the reorganization of J&K, now it is applicable to J&K also, that is to the Union Territory of J&K. Now, another thing is like in which provision of IPC there is the intra-territorial operations mentioned. So, intra-territorial operations of IPC is there in section number 2 of the IPC, that if any offense is committed within the jurisdiction of India, it will be punishable under the Indian Penal Code. But there is a very important case, that is Mubarak Ali Ahmed versus State of Bombay, 1957 Supreme Court. Mubarak Ali Ahmed versus State of Bombay, 1957 Supreme Court, where a person who was a resident in Karachi, he came in contact with a person who was residing in India, and an offense of cheating was conducted. Now, the question comes that the offender was outside India and the offense is committed within India. Can that person be held liable within India? The answer is yes. The court stated that it is the location of the offense which is relevant. It is not the location of the offender. So Mubarak Ali Ahmed is a very important judgment on this point, that if any person who is residing outside India and he committed an offense within India, then whether that person will be held liable or not. So it is this particular offense section number 4, as well as section number 3, as well as section number 2, which is talking about the territorial operations of the IPC. Section number 2 is primarily with respect to the intra-territorial operations, and section number 3 and 4 are related with the concept of extraterritorial operations of IPC. Okay, now section number 4, that the question comes that in which provision of IPC the extraterritorial operations are mentioned. Extraterritorial operations of IPC. So it is section number 4 which talks about that yes, IPC is having some extraterritorial operations also. Like the next question comes that in which cases the extraterritorial operation will be applicable. The answer is if any citizen of India in any place without and beyond India, that person commits an offense, that yes, that such person can be tried within India as per IPC also. If any person commits an offense, any person means any Indian national or as well as any foreign national, if such person commits an offense within an Indian ship or aircraft, within an Indian ship or Indian aircraft, then against such person also, the provisions of IPC will be attracted. And the third one is any person at any place without and beyond India committing or targeting any computer resource located in India. So in such cases, whosoever is the offender is, against that offender, the provisions of IPC will be applicable. The provisions of IPC will be applicable, and that is what is called as the extraterritorial operations of the IPC. But now the question comes that if a person has committed an offense outside India, so how IPC will be applicable over such person? So the answer is given to this point is in section number 3, that section 3 draws a bridge that where a person has committed an offense outside India, but IPC is not applicable outside India. So how that person can be made liable with respect to the Indian Penal Code? So section number 3 is saying that if any person commits an offense outside India for which he is liable under IPC, as if the offense is committed within India, the such person shall be triable at a place wherever the accused is found, wherever the accused is found. And section number 188 of the CRPC's counterpart of this, it both the provisions, that is section number 4 and section number 188 of the CRPC, read together with section number 3, are to be read in corollary with each other. Like there is a person, like for example, an Indian national who is there in Australia. He committed an offense in Australia, and then that person came back to India. Now, in Australia, IPC is not there. IPC is only applicable within India. But against such person, the proceedings of extradition will be demanded by the Australia government. So, how the things will be taken up? So, if in India this person is arrested, either this person will be extradited to the foreign country, or if the extradition is not allowed, then such person can be punished within India also. But how? The question comes that how we can make this person liable. So the answer is given in section number 188, read with section number 3, 188 of CRPC, section number 3 of IPC, that wherever the accused is found, we will assume that such person has committed that offense at such place. हुआ नहीं है वहां पे अपराध, लेकिन माना जाएगा that such person has committed that offense at such place. Now, coming to the next area of discussion on this, section number 3 and 4 primarily related to the extraterritorial operations, and section number 3 altogether talks about the intra-territorial operations. Now, there will be section number 5. Look, section 5 is generally stating that it specifically stated nothing in this section shall affect the provisions of any act for punishing and desertion of the soldiers, sailors, or airmen in the service of the government, or the provisions of any special or local law. So, if anything which is punishable under any special or local law, or it is an offense which is being committed by the deserters from the armed forces, then if any special law is there, that special law is going to prevail. And there is a maxim also on this point, that is generalius specialibus non derogant. That is, a special law is given superiority over the general law. So IPC is a general law, and the special laws, local laws, or any law which is related to the deserters is considered to be a special law, and special law will always prevail. So iska aapko dhyan rakhna hai. Now coming to the next portion, that is what is relevant from section number 6 onwards, section number 21. All the sections are not important with respect to the prelims, but yes, certain sections are important. Like section number 6, it talks about that the journal exceptions given in chapter number 4 of the IPC will be taken up and read together with the whole of the IPC. तो बार-बार आपने exceptions को नहीं लिखा है, exceptions एक ही बार लिखी गई है, लेकिन उनको पूरे IPC के साथ जो है वो पढ़ा जाता है. There is an illustrations given in section number 6 itself. Just go through with those illustrations also. As we can read over here, that a police officer without warrant apprehends it who has committed a murder. Here he is not guilty of an offense of wrongful confinement because he is bound to do that, and therefore the case falls under the general exception, which provides that nothing is an offense which is done by a person who is by law bound to do it. So if any person who is bound by law to do it, and under a mistake of fact he does that particular some other act, then there is a protection given in section number 76 of the IPC with respect to such persons. So section number 6 is generally giving a declaration that okay, wherever the journal exceptions are there, whatever the journal exceptions are there in chapter number 4, all the journal exceptions will be taken up and read together with all the penal provisions of the Indian Penal Code. Thereby, the next section which is important for you people, that is section number 19, that who will be called to be a judge. जज की डेफिनेशन जो है सेक्शन नंबर 19 के अंदर है. व्हाट इज इंपॉर्टेंट, दैट इज द थिंग्स व्हिच आर मेंशन्ड इन द इलस्ट्रेटिव पार्ट, दैट इज अ कलेक्टर exercising jurisdiction in a suit of Act number 10 of 1859 is called to be a judge. That is basically the land acquisition proceedings are there, which is being taken up by the collector. Similarly, a magistrate exercising jurisdiction of a charge of which he has a power to sentence of fine and imprisonment with or without appear is called as a judge, appears to be a judge. Next one is any member of panchayat. Any member of panchayat who has a power to determine and try suits is also a judge. But the most important illustration is illustration number D, where it is stating that a magistrate exercising jurisdiction in respect of a charge, and he has only power to commit for the trial to another court. Magistrate is only taking the cognizance but he has no power to try the matter. Trial will only be taken up by the other court. Like for example, court of session is the court by which the trial is to be committed, and magistrate is required to commit the case to the court of session. So in such case, magistrate will not be called to be a judge. ऐसी situations में magistrate को आप judge नहीं बोलोगे. So these things are very important. In MCQ, such kind of question comes that whether a magistrate is a judge or not, whether collector is a judge or not. Section number 19 will be taking care of it. Next thing is the important definition given in section number 21, that is of public servant. Who is called to be a public servant? Question comes that in which provision it is mentioned. It is mentioned in section number 21 of the IPC. But apart from that, there are certain other things which are relevant with respect to this particular definition. And these are the things which you people can see on your respective screens. There was a committee in 1964, that is the Sanathan Committee report was there, in which it was stated that a member of Legislative Assembly is not a public servant. Member of Legislative Assembly is not a public servant. But after the enactment of the Prevention of Corruption Act, an MP or MLA can be considered as a public servant for the purpose of the said act. So it is a special kind of a provision which is specified in the Prevention of Corruption Act. So if the MCQ comes, in the prelims exam, then if it is mentioned that is MLA is a public servant, member of Legislative Assembly is a public servant or not, the answer is no, he is not a public servant. Reason being, Sanathan Committee report is there. Apart from that, the different other options which you people might be getting in the exam, that is a person appointed as an examiner by the university, even if he is a lecturer of a government college, is not an officer, and therefore he is not a public servant under section number 21. So any person who is an examiner of the university is not to be called as a public servant. Next is, do a chairman of a cooperative society is a public servant? The answer is no. The chairman of a cooperative society is not to be called as a public servant. And there are multiple definitions given with respect to this, these pointers. And we have one judgment, that is Ramesh Balakrishna Kulkarni versus State of Maharashtra 1985, whereby the court had stated that a municipal councillor is not a public servant within the meaning of section number 21. Municipal councillor is not a public servant. So such kind of question comes, and these are the tricky questions with respect to the judiciary exam, and whether you are able to assess that which person is a public servant or which is not a public servant. Just go through with the basic definition of section 21. That section 21 usually say that any person who is in the services of the government, any judicial officer, any person taking remuneration from the government is called to be a public servant. But कौन व्यक्ति public servant नहीं है, ये आपको पता होना चाहिए. And this is being given in these different judgments that we discuss. Sanathan Committee report is there, which we follow. Now coming to the next point, that what is there in section number 22. Section 22 talks about that what is a movable property. So movable property means the property which has a capability of changing its place. So movable property does not include land and things attached to earth, permanently fastened to anything which is attached to earth. So these are not the movable properties. Movable properties are those which are corporeal in nature, which can change their particular place. Another definition is there, that is the definition of wrongful gain and wrongful loss. So if any person is getting something for which he is not lawfully entitled, any person is getting something for which he is not lawfully entitled, then if such person is getting some benefit, then it will be called to be the wrongful gain. And similarly, if there is a wrongful loss, we say that if a person who is being deprived of particular thing, that he will be suffering a wrongful loss from that wrongful loss. And a very, very important judgment on section number 23, that is K.N. Mehra versus State of Rajasthan 1957 Supreme Court, whereby the two cadets of the Indian Air Force have taken an aircraft from Jodhpur to Pakistan, and they landed that particular aircraft in Karachi. So it was basically that they had caused a wrongful loss to the Indian Air Force, and they were liable for the offense of theft. For the offense of theft, that is section number 378, because theft means what? Whenever you have a dishonest intention of doing something, and dishonest intention means what? That whenever a person is getting any wrongful gain, or he is causing any wrongful loss to the other person. So wrongful gain and wrongful loss are the very key factors to understand that whether the thing is done dishonestly or not. After that, the another important point, that what is the term fraudulent. So the term fraudulent is being defined in section number 25 of the Indian Evidence Act. Fraudulent means what? And a person is said to be doing a thing fraudulently if he does that thing with the intention to defraud but not otherwise. Now this definition is not making it very clear that what actually the term fraud is. So the term fraud is directly associated that if you are causing any kind of a loss to any person, any kind of a loss to any person, then it will be called to be that you are doing that thing fraudulently. And in Union of India versus Ravinder Singh 2011 Supreme Court, Union of India versus Ravinder Singh 2011 Supreme Court, it was stated that what is the difference between the term fraudulent and dishonest, between the term fraudulent and dishonest. So I will ask you people who can tell me that what is the basic difference between fraud and dishonest. I will be giving you 1 minute for this. Please mention me what is the difference between fraud and dishonest. Let me see who give me the right answer. Yes, what is the difference between fraudulent and dishonest? कौन बताएगा? No one. Ainika, Tanya, and those others who are there in the session today. Look, with respect to the term defraud, as it is specified by the Honorable Supreme Court, that the expression defraud involves two elements, that is to deceive and to cause injury to the person deceived. And injury is something other than the economic loss. Other than the economic loss, that is deprivation of the property, whether movable or immovable, or of money, and it will include any harm, whatever caused to any person in mind, body, reputation, or in short, it is a non-economic or non-pecuniary losses also. So whenever we use the term dishonestly, whenever we use the term dishonestly, it is directly associated with wrongful loss and wrongful gain, and it apparently denotes that pecuniary losses are there. But whenever we use the term fraud, then fraud includes two things. Number one, there is a deception, and after the deception there is a injury or harm caused to the other person, and injury and harm can be a pecuniary loss or it can be a non pecuniary loss. ठीक है, तो fraud और dishonestly में फर्क है. I hope yes, many of you have given me the answers to this. Shaktija is saying fraud is a genus and dishonest is a species. Very good. Very good. So fraud is a bit kind of a broader term in which the pecuniary as well as the non-pecuniary losses usually covered. Now the next definition which is important for you people, that is reason to believe. Reason to believe, directly question can be there. Like what is reason to believe? That whenever there is a sufficient cause to believe over something, it is to be called as a reason to believe. After that, section number 27 states that if a property of a person is in the possession of his wife, clerk, or servant, possession of the property is with the wife, clerk, or servant, then it will be deemed as if the intelligent possession was of that person only. It is written that property in possession of wife, clerk, or servant is said to be in that person's possession, and the possession must be an intelligent possession, not merely a physical presence of accused in proximity to the object. So section number 27 is having a very high reference with respect to the definitions and the illustrations given in section number 378 of the IPC. Whenever we used to see that what are the illustrations given in the definition and of theft, so there it is written that if a property was in the possession of wife, but still it is considered to be in the possession of that particular person. So that is the importance of section number 27. 28 says generally it can be the direct question that where the counterfeiting is defined. Counterfeiting generally means whenever you try to make something which is resembling to the other thing. Like there is a currency for, and you made a counterfeited currency which is resembling to the original one. So that usually means that what is the meaning of counterfeiting. And apart from that, the definition of counterfeiting that is given in section number 28, it is directly to be associated with the area, that is section number 230 onwards, which is relating with the concept that how the counterfeiting is an offense, what kind of punishments can be there. But generally, it is an offbeat kind of an area. No direct questions usually come from this portion. Then you see the important definition, that is of valuable security, section number 30. Valuable security is basically a document whereby a particular security is created, any right is created, right is extinguished of someone, any right is transferred to someone, then that thing will be called to be the valuable security. So every document cannot be called to be a valuable security, rather only those documents by which any right over a particular thing has been created or transferred or extinguished or made, such things are to be called as the valuable securities. So basic things are there, but yes, the most important definitions which you people have to see, that is of section number 6, which directly comes in the exam, section number 19, section number 20, section number 21. यहाँ से सीधा सीधा सवाल पूछा जाता है. देयर आफ्टर wrongful gain, wrongful loss, fraudulent, dishonest, ये डेफिनेशंस थोड़ी सी ज्यादा इंपॉर्टेंट है, ठीक है, अपार्ट फ्रॉम द अदर डेफिनेशंस. तो इनके ऊपर आपको ज्यादा फोकस रखना पड़ेगा. इसके साथ साथ the next thing that is important for you people, that is onward section number 34, that is common intention, a very basic provision with respect to the Indian Penal Code. And now what kind of questions can be there from section number 34? Like two questions usually the examiner put. One is the direct question, which apparently that what are the ingredient of section number 34, do 34 creates any specific offense or not. Section number 34 is a rule of evidence or it is something else. So what is the right answer, what should be the right answer? That section 34 creates no specific offense. It is only a rule of evidence. It is not a substantive offense. It is not a substantive offense. सेक्शन 34 अपने आप में कोई अपराध नहीं है, ये सिर्फ एक रूल ऑफ एविडेंस है और इसके बेसिस पे आप लोगों की लायबिलिटीज को फिक्स कर सकते हो. एंड द वर्ड्स यूज्ड इन सेक्शन 34, दैट इज इन फर्दरेंस ऑफ द कॉमन इंटेंशन ऑफ ऑल, वर एडेड इन सेक्शन 34 इन द ईयर 1870. ये पूछा जाता है कि ये इन फर्दरेंस ऑफ कॉमन इंटेंशन फॉर ऑल ये कब ऐड हुआ? सो इट वाज एडेड इन द ईयर 1870. नाउ कमिंग टू द जजमेंट्स related to section 34, that Shankari Tola post office murder case किसको कहा जाता है? Virendra Kumar Ghosh versus King Emperor. Who are the judges in this particular case? This is Justice Atkinson, Justice Sumner, and Justice Edge has given this particular judgment. The author is Justice Sumner, and this the important line given in this particular case law is they also serve who स्टैंड एंड वेट. ठीक है, कोई भी व्यक्ति अगर खुद एक्ट नहीं कर रहा लेकिन वो बाकियों का वेट भी अगर कर रहा है, इवन देन आल्सो सच पर्सन इज लायबल फॉर द मेन ऑफेंस व्हिच इज बीइंग कंडक्टेड बाय द अदर co-accused persons. इसके बाद another important case in which the court has given the difference between the common intention and common object. Common intention and common object definition, this difference was given in the case of Nanak Chand versus State of Punjab. A very very important judgment. कभी भी आपको रिटर्न में कोई क्वेश्चन आ जाए दैट व्हाट इज द डिफरेंस बिटवीन कॉमन इंटेंशन एंड कॉमन ऑब्जेक्ट, यू कैन मेंशन नानक चंद वर्सेस स्टेट ऑफ पंजाब 1955 सुप्रीम कोर्ट. देयरआफ्टर अनदर कॉन्सेप्ट रिलेटेड टू द सेम पॉइंट, दैट इज सिमिलर इंटेंशंस. ऑफ सेम इंटेंशंस क्या हैं? सो सिमिलर और सेम इंटेंशंस आर बीइंग स्पेसिफाइड इन सेक्शन नंबर 35. अ वेरी इंपॉर्टेंट केस, दैट इज महबूब शाह वर्सेस किंग एम्परर. जस्टिस माधवन नैयर has given the judgment and the bench was of M. Nair, Thankerton and Justice Beaumont. So J. Beaumont. So these three are the judges in this particular case. Justice Mahbub Shah versus King Emperor. And the court has given the difference in this particular case law, that what is the difference between common intention and what is a difference of common intention with similar intention. So common intention is when the more than one person are sharing their intention with each other, and then for achieving a particular object they proceed further. But similar intention is something else. Like a persons are having the similar intention, but there is no sharing of the intention between them. So whenever there is no sharing of intentions, but same kind of intentions are there, then section number 35 is going to be applicable. Now, thereafter, section number 36 is there, that when an act is done and partly there is an act and partly there is an omission, and ultimately a consequence is there. So, how we are going to make such person liable? So, as it is specified in section number 36, illustration is important in this part, that A intentionally causes Z's death partly by illegally omitting to give him food and partly by beating Z. So A has committed murder. Though directly, neither the omission of the food may be causing murder, and neither the beating which he has given to the opposite party has will be resulted in murder, but the combined effect of both the things has resulted in the murder, so he should be liable accordingly as given in section number 36. 37 cooperation की बात करता है, like if one or more persons are having a cooperation while doing one or several acts, so whosoever had cooperated intentionally, they all will be liable for the ultimate outcome of the concerned act. So in this particular definition, section number 37, illustrations are important. Both the illustrations are important. That is illustration number A as well as illustration number B. ये यहाँ से सवाल ज़्यादा आता है. Illustration number C कभी-कभी पूछ लेते हैं, लेकिन you must have to focus on all the three. It is written that look, A and B, there are two persons. They agree to murder Z, but severally at different times. Now they are not giving the act jointly, but at different times they are putting up their acts. And there is an agreement that okay, we will be giving poison to Mr. Z simultaneously, and accordingly they did it. They gave small doses of poisons to Mr. Z, and लिखा ना A and B administers poison according to the agreement with intent to murder Z. Z dies from the effect of the several doses of poison so administered to him. So A and B have because they have intentionally cooperated each other. Because they have intentionally cooperated each other, both of them should be liable for an offense, though their acts are separate. इसके साथ साथ as you people see illustration number C, इसमें देखो, इसमें आपका एक्ट अगर डिफरेंट रहेगा और there is no intentionally cooperation is there, then you will not be liable for the same punishment, we can say. So it is written that A jailer having a charge of Z a prisoner, A intends to cause Z's death, illegally omitted to supply food to Z, and Z is much reduced to strength, but due to starvation it was not sufficient to cause the death. A was dismissed from the services. B without collusion or cooperation with A. B नाम का व्यक्ति नया जेलर आया, उसका कोई cooperation नहीं है A के साथ. He also illegally omits and to supply Z food, and thereby Z dies because of hunger. So B will be guilty for murder and A will only be guilty for attempt to murder. यहाँ से सवाल बहुत बार आता है, ठीक है? Just mark it on your concerned pair acts. Illustration number C. Thereafter, illustration number 9 में पूछा गया that what means voluntarily. So voluntarily includes three things: anything which is done with the intention, anything of which is done with the knowledge, and anything of which a person is having a reason to believe. So intention, knowledge or reason to believe, तीनों में से कोई भी चीज अगर मिल जाए, it will be considered to be that the act is done voluntarily. That act is done voluntarily. इसी के साथ साथ the illustration given in this particular section is also important. Illustration is important that if a person sets out a fire by night at the inhabited house in a large town, and for the purpose of facilitating a robbery, and whereby the death of a person is caused. Now, in such a case, A may not have intended to cause the death, but he is having the knowledge, and because he is having the knowledge, he would be said to be that the act of death of the person is caused voluntarily. Thereafter, the word offense is there. Offense means anything which is punishable by law. But now from here, I will be asking you one question, that in IPC, which provision is stating about something which is not an offense? ऐसी कौन सी चीज है जो डिफाइन तो है लेकिन हम उसको ऑफेंस नहीं मान सकते? Any one of you who can give me the answer to this? Yes, everyone. Offense as per section 40 states that anything which is made punishable by IPC. My question to you is, do there is anything specified in IPC which is not to be called as an offense, but yes, it is defined under the penal provisions? Yes, anyone? Shaktija, Anika, Ratika. Any guesswork on that? Like there are multiple offenses, na? Like for example, murder, kidnapping, etc., and so on. So anything which is made punishable under IPC is called to be an offense. But the question is, there is an exception to this. What is that exception? Arzu thinks journal exception. No, no journal exceptions are not there. Offense means something which is punishable by IPC. Anything which is defined but it is not punishable under IPC. So if people are seeing defenses, look, there is a thing which is called as abduction. Do abduction per se is an offense? Abduction per se is an offense. Yes. अरे महक एडल्ट्री नहीं है, एडल्ट्री नहीं है, एडल्ट्री तो डीक्रिमिनलाइज हो गया ना. एबडक्शन की बात करेंगे, एबडक्शन की बात करेंगे. क्या एबडक्शन अपने आप में ऑफेंस है? Do abduction is itself an offense? Yes or no? Yes or no? Yes. देखो, abduction per se is not an offense. Abduction per se is not an offense. Why we say so? Because for abduction, only for abduction, there is no punishment given in IPC. Abduction is punishable only when some other factors are associated with the abduction, like abduction for the purpose of committing illicit intercourse, abduction for the purpose of murdering someone, then abduction is punishable. But merely if there is an abduction, if you take away one person from one place to another, it is abduction. But per se, abduction is not punishable. Abduction की अपने आप में कोई punishment directly नहीं है. जैसे kidnapping है, तो kidnapping करने का punishment है. ठीक है. फिर किडनैपिंग फॉर रैंसम, किडनैपिंग फॉर द ऑब्जेक्ट ऑफ कमिटिंग मर्डर एटसेट्रा, उनकी फिर पनिशमेंट्स अलग अलग है. लेकिन एबडक्शन हमारे पास डिफाइंड है, बट एबडक्शन की कहीं पे भी पनिशमेंट नहीं है डायरेक्टली. एबडक्शन की पनिशमेंट अगर होगी तो वो केवल तब होगी जब एबडक्शन के साथ कुछ और भी एसोसिएटेड है, लाइक एबडक्शन विद द पर्पस ऑफ हैविंग एन इलिसिट इंटरकोर्स, देन एबडक्शन विल बी पनिशेबल. तो मेयरली abduction is not punishable, and then we can say कि जैसे offense की definition के लिए offense means something which is punishable by IPC. So abduction per se is not an offense. Reason being abduction is not directly punishable. Abduction को punishable बनाने के लिए कुछ और चीजें abduction के साथ हमें चाहिए होती है. ठीक है. इसके बाद आपका section number 41 and 42 talks about the special laws and local laws. Special law means a law which is there on a particular subject, and local law means any law which is applicable to a particular part of India. Like there is a Port Trust Act. So Port Trust Act is applicable only to the area where the port is. Okay, like the shipments are there, port is established, only there that Port Trust Act will be applicable. It does not apply to the other part of the country. The next definition that is important, that is the definition of the word illegal. Illegal means anything which is an offense, anything which is prohibited by law, or anything which creates a ground for civil action. Okay, anything which is done, which is an offense as per IPC, it means something which is punishable under IPC. Anything which is prohibited by law, it means anything which is prohibited by any other law apart from IPC, or anything which creates a ground for civil action. Such things are called to be illegal. And if a person is omitting something which is not legally fine, if the person is omitting something which is called to be an illegal omission, so that is also considered in the definition of section number 43. And apart from that, in the first law commission it is stated, in the first law commission it was stated that there is no difference between unlawful and illegal with respect to the Indian penal code. अगर आईपीसी में कहीं पे अनलॉफुल या इलीगल वर्ड डाला गया है तो इन दोनों में कोई डिफरेंस नहीं माना जाएगा. Another question which is there from section number 44, that what is meant by injury? Injury means any harm which is illegally caused. Illegally means anything which is an offense, anything which is prohibited by law, or anything which creates a ground for civil action. So any harm which is illegally caused to mind, body, reputation or property. तो यहाँ से MCQ बन जाता है, इसका ध्यान आप रखेंगे. Next one is where the good faith is defined. Section number 52. Good faith means due care and attention is to be taken up. And thereafter 52 capital, it talks about harbor. It was inserted in the year 1942, and harbor means giving shelter, food or clothing to any person so that his arrest can be evaded. Or but the point is that if the harbor is given by a wife or a husband of the concerned person, then it will not be called to be an offense. So section number 157 and 130 are created as an exceptions to section number 52 capital A, and the person will not be liable. Another chapter that we are going to start now is where the punishments and what kind of punishments are there in IPC. How many types of punishments are there in IPC? It is 5 kinds of punishments are there. That is death, life imprisonment, that is simple or rigorous imprisonment, forfeiture of property, and fine. So these are the 5 kind of punishments which are mentioned in chapter number 2, section number 53. Now there are different theories of punishments. Though it is not that much relevant with respect to the MCQ, but yes, you must have to take care of it. Like there is a retributive theory, that is eye for eye, tooth for tooth. So it is basically applicable there in the Arab countries. Thereafter, there is a deterrent theory, that is to set an example for the others. Thereafter, it is a preventive theory, that is suspension or cancellation of the licenses or withdrawal of anything. It is to prevent something. And thereafter, it is explanatory theory, that is purification of the offense. And last one is the reformative theory, that is to restore the man in society as a wise man or a good citizen. My question to you people is, इंडिया में कौन सी थ्योरी अप्लाई होती है? Which theory of punishment is applicable in India? There are 5 theories on your screen. Which theory is applicable in India? Yes, everyone. कौन बताएगा? Which theory is applicable in India? Reformative है, deterrent है, कौन सी थ्योरी है? Reformative theory is there which is applicable in India. Very good. चलिए, coming to the next point. अब यहाँ से ये जो आपका एरिया है ना, section number 53 onward section number 75 तक, a lot of MCQs usually come with respect to the dates, amendments, when the concerned provision was inserted. इनका थोड़ा सा खास ध्यान वैसे रखना पड़ेगा आप लोगों को. The first question is कि look, before 1955 there was a punishment that was transportation for life, but after the amendment of 1955 this punishment was omitted and there was a new punishment, that is rigorous imprisonment is there and life imprisonment is there, but transportation of life, जिसको काला पानी की सजा कहते थे, वो अब हटा दी गई. तो transportation of life was omitted by the act of 1955 and it came in force on 1st of January 1956. So एक date आपके लिए important है. Thereafter another question which is there, that is from section number 54, कि अगर डेथ सेंटेंस को कम्यूट करवाना है तो कौन करेगा? सो appropriate government can go for the commutation of the death sentence, but whenever the commutation is to be done, it is done by the government, but important point is it can be done without the offender of the concern of without the consent of the offender. Without the consent of the offender, आपको offender का consent लेने की जरूरत नहीं है कि तेरी सजा हम कम करें या ना करें. You can go for the commutation of the death sentence. Thereafter, the next thing is commutation of the life imprisonment. So yes, you can go for the commutation of the life imprisonment also, but it should not be exceeding 14 years. 14 years से ज्यादा नहीं आप रखोगे फिर punishment, उससे कम ही रखोगे. और अगर death sentence को commute किया जा रहा है तो उसको life imprisonment में commute किया जा सकता है. And appropriate government means either the central government or the state government. Another question is that which comes from section number 57. 56 तो रिपील हो चुका है, that is removal of the racial discrimination act 1949 के थ्रू ये रिपील हो गया था. सेक्शन नंबर 57 आपके लिए इंपॉर्टेंट है कि whenever the life imprisonment is taken up, generally the life imprisonment is considered to be the whole of the life, but for if any calculation is required to be done, fractions of life imprisonment are to be taken up, then it is to be counted for 20 years पीरियड। ठीक है, कभी भी आपको कोई कैलकुलेशन करनी हो लाइफ इम्प्रिजनमेंट के, इसको देखने के लिए हम 20 साल मान के चलते हैं, लेकिन लाइफ इम्प्रिजनमेंट का मतलब ये नहीं है कि 20 साल, सिर्फ कोई कैलकुलेशन अगर करनी है तो उसके लिए हम 20 साल की एक फिगर जो है उसको लेके चलते हैं। Thereafter, section number 58 and 59, they are again repealed by the CRPC Amendment Act 1955. Section number 60, it is saying that imprisonment can be wholly or partially rigorous or simple as the case may be. जैसा offense है वैसा पता लग जाता है। 61 and 62 again repealed by the Act of 1921. ये डायरेक्ट सवाल कभी कभी पूछते हैं, ट्रिकी क्वेश्चंस पूछते हैं आपको परेशान करने के लिए। Thereafter, the question comes that whenever the fine is imposed over a person, do the fine amount can be unlimited? The answer is yes, it can be unlimited, but it should not be excessive. It should not be excessive. इसका ध्यान रखना है आपने। Next one, if a person commits an offense, the court gives him imprisonment as well as the fine is imposed over that person does not pay the fine, then for the default of the payment of fine, do that person can be imprisoned? The answer is yes. Section number 64 and 65 talks about that, and which provision of CRPC is associated with this. In the CRPC also we have taken up one section. Which section of CRPC is related with section number 65 of the IPC? कौन बताएगा? Which section of CRPC is directly associated with section number 65 of the IPC? That imprisonment for the non-payment of fine shall not exceed 1/4 of the maximum term provided for that particular offense. Very good, Pooja. It is section number 30 of CRPC. Very good, very good. Now the next thing is, if a person has defaulted the payment of fine and the imprisonment is to be ordered, then imprisonment can be simple or it can be rigorous imprisonment. But if the offense is punishable only with fine, अगर किसी अपराध की सजा केवल मात्र जुर्माना है, फाइन है, और उस व्यक्ति ने फाइन जमा नहीं करवाया, द पर्सन हैज नॉट डिपॉजिटेड द फाइन, तो उसको इम्प्रिजनमेंट अगर दी जाएगी तो ओनली सिंपल इम्प्रिजनमेंट कैन बी given to such person. इसका ध्यान रखना है 67 में, if the fine is only the punishment and the person is defaulted, only simple imprisonment will be given to such person. Okay, इसके बाद आपके लिए section number 69 is important. 69 is important. Now in 69 it is saying that okay, what will be the maximum punishment if the person has defaulted the payment of the fine, and when the punishment will be terminated. So it is saying that, just give me 1 second. Yeah, so section number 68 and 69 are on this particular point. Like, you people tell me that if the fine is up to ₹50, then what will be the maximum punishment given? If the fine is up to ₹50, कौन बताएगा? अगर आप लोगों ने IPC पढ़ा है तो बताइए. If the fine is up to ₹50, what is the maximum punishment which can be given to such person? Imprisonment. And if the amount is from 50 to 100, then what will be the time period? And if it is more than ₹100, then what? So if the fine is up to ₹50, it is 2 months. If 50 to 100, then 50 से 100 रुपए तक का जुर्माना है तो कितना रहेगा? 4 months. Very good. And if it is more than ₹100, then yes, Anika. If the fine is more than ₹100, then 6 months. Very good. Very good. So this is the time limit for the imprisonment which is being given. Section number 68 and 69 are taking care of it. And if any person to whom the imprisonment is given because of the default of the fine, and that person pays any proportional part of that, then he will be released, or after the termination of the imprisonment he will be going to be released. तो ये यहाँ पे पूरा वो बनाया कि एक इलस्ट्रेशन दिया गया है कि अगर किसी के ऊपर 100 रुपए का जुर्माना लगा तो उसने कितने पैसे जमा करवाए तो कब उसको रिलीज कर दिया जाएगा, उसको आप एक बार जरूर देख के रखेंगे. ठीक है, तो जनरली ये जो एग्जाम में सवाल आता है वो ये आ जाता है कि इफ द फाइन इज अप टू ₹50, व्हाट कैन बी द मैक्सिमम इम्प्रिजनमेंट टू बी ग्रांटेड टू सच पर्सन. Thereafter, the next thing is that let us come to the next area of discussion. Section number 71 directly इतना ज्यादा तो नहीं पूछा जाता, but फिर भी it is also correlated with section number 31 and 220 of the CRPC, that if a person has illustration काफी बार पूछा जाता है that if a person gives 50 strokes with a stick to the other person, he may have committed an offense voluntarily causing hurt by the whole beating and also by each of the blows. But if ever be liable for the punishment of each blow, he might be imprisonment for 50 years. क्योंकि हर बार के लिए आप 1 साल की सजा दोगे तो 50 साल की सजा होगी, तो ऐसा नहीं होगा. He will only be liable for one punishment for the whole beating. इसका आपको ध्यान रखना है, जो सेक्शन नंबर 71 के अंदर है. सवाल आ जाता है सेक्शन 71 of IPC is associated or correlated with which provisions of CRPC? Section number 31 read together with section number 220 of the CRPC. The next thing is सेक्शन नंबर 73 में एक छोटा सा कॉन्सेप्ट है जो आपको पता होना चाहिए, दैट इज रिलेटेड टू द कॉन्सेप्ट ऑफ सॉलिटरी कन्फाइनमेंट. Look, if the imprisonment is given to a person which is less than 3 years, less than 6 months, then the maximum period of solitary confinement will be 1 month. If the punishment which is given to the person, rigorous punishment which is given to a person, is up from 6 months to 1 year, then the maximum term of solitary confinement will be 2 months. Okay, and if the punishment which is given to a person that is 1 year and you want to go forward the person for the solitary confinement also, then the maximum period of solitary confinement will be 3 months. ठीक है, तो अगर मैक्सिमम सजा 6 महीने तक है तो सॉलिटरी कन्फाइनमेंट में व्यक्ति को 1 महीने तक रखा जा सकता है. अगर 6 महीने से 1 साल के बीच की सजा दी गई है तो 2 महीने तक सॉलिटरी कन्फाइनमेंट हो सकता है, और अगर 1 साल से ज्यादा है तो 3 महीने तक का सॉलिटरी कन्फाइनमेंट दिया जा सकता है. इसके बाद सॉलिटरी कन्फाइनमेंट की भी एक लिमिट है कि 14 डेज एट वन टाइम, फिर उसके बाद 14 डेज का इंटरवल रहेगा, फिर 14 डेज के बाद आप उसको दोबारा से सॉलिटरी कन्फाइनमेंट में भेज सकते हो. लेकिन अगर इम्प्रिजनमेंट जो थी वो 3 महीने से ज्यादा की है, जैसे मैक्सिमम इम्प्रिजनमेंट मान लो 6 महीने, तो इस केस में अगर आप उसको सॉलिटरी कन्फाइनमेंट में व्यक्ति को भेजना चाहते हो, देन इन 1 मंथ ओनली 7 डेज सॉलिटरी कन्फाइनमेंट कैन बी अवॉर्डेड. ये बड़ा एक इंपॉर्टेंट ट्रिकी सी चीज है कि कैसे इसकी कैलकुलेशन होती है. नॉर्मली 2 चीजें हैं सेक्शन नंबर 73 के अंदर जो बताता है कि सॉलिटरी कन्फाइनमेंट का मैक्सिमम टाइम पीरियड क्या रहता है, दैट इज मेंशन्ड. इसके बाद की लिमिट क्या रहेगी, इंटरवल्स कितने रहेंगे. तो अगर 3 महीने से कम वाली कोई इम्प्रिजनमेंट दी गई है और आपको उस व्यक्ति को सॉलिटरी कन्फाइनमेंट में भेजना है, जो कि मैक्सिमम आप 1 महीने तक ही भेज सकते हो, तो उस केस में 14 डेज का टाइम स्लॉट रहेगा, फिर 14 डेज का इंटरवल, फिर 14 डेज के लिए आप उसको फर्दर सॉलिटरी कन्फाइनमेंट में रख सकते हो. लेकिन अगर इम्प्रिजनमेंट जो ऑर्डर हुई है वो 3 महीने से ज्यादा की, इम्प्रिजनमेंट इज फॉर मोर देन 3 मंथ्स, तो फिर 1 महीने में 7 डेज तक की सॉलिटरी कन्फाइनमेंट में व्यक्ति को रखा जाएगा. ठीक है, तो एक छोटी सी चीज है जिसका आपको ध्यान रखना है. सेक्शन नंबर 75 टॉक्स अबाउट द कांसेप्ट ऑफ एनहांस पनिशमेंट. क्वेश्चन कम्स की सेक्शन 75 कौन से प्रोविजंस, कौन से चैप्टर्स के लिए अप्लाई होता है. तो 2 चैप्टर्स आर देयर. देयर इज चैप्टर नंबर 12 टॉकिंग अबाउट द काउंटरफिटिंग ऑफ कॉइंस, एज वेल एज चैप्टर नंबर 17 which talks about the offenses against property. अगर किसी भी व्यक्ति ने चैप्टर 12 या चैप्टर 17 के अंदर कोई अपराध किया और दोबारा से वैसा ही कोई ऑफेंस इन्हीं चैप्टर्स के अंदर कमिट करता है, so that person is liable for the enhanced punishment provided कि for an offense punishable with not less than 3 years. It is not necessary that 3 years imprisonment is awarded to such person. जो भी अपराध उस व्यक्ति ने पहले किया उसकी कानून में 3 साल तक की सजा कम से कम अगर है, और कितनी कोर्ट ने उसको सजा दी दैट इज नॉट मटेरियल, और बाद में दोबारा से सब्सिक्वेंटली ही कमिट्स द सेम काइंड ऑफ एन ऑफेंस अंडर द सेम चैप्टर और डिफरेंट ऑफेंस अंडर द सेम चैप्टर, द पर्सन इज लायबल फॉर द एनहांस्ड पनिशमेंट. It is written that for the subsequent offense under the same chapter the punishment can be imprisonment for life or it may extend up to 10 years. तो ये चीजें सेक्शन नंबर 75 से enhanced punishment का जो कॉन्सेप्ट है ये पूछ लिया जाता है. Now coming to the general exceptions. General exception section number 76 till 106. ठीक है, यहाँ पे आप देखते हैं कि क्या क्या चीजें आपके लिए रेलेवेंट हैं. देखो, जहां तक सेक्शन नंबर 76 का बात है, इट इज सेइंग दैट अ पर्सन हैज डन समथिंग अंडर अ मिस्टेक ऑफ फैक्ट and that person is believing himself to be bound by law or he was bound by law to do it, then whatever is done by that person he should not be made liable for that. Section number 6 के अंदर भी हमने एक illustration देखा, वो इसी से related है. bound by law जो व्यक्ति है, if he is doing something under a mistake of fact, then that person will be getting the defense. There is a very important case on the doctrine of respondent superior कि अगर किसी superior ने अपने subordinate को कुछ order दिया, that order was in conformity with the law and the subordinate had obeyed that particular order, तो सिर्फ जवाबदेही सुपीरियर की बनती है, सबॉर्डिनेट की रिस्पॉन्सिबिलिटी नहीं बनेगी. वेरी इंपॉर्टेंट केस लॉ, दैट इज स्टेट ऑफ वेस्ट बंगाल वर्सेस शिव मंगल सिंह. तो इसका आपको ध्यान रखना है, ये केस बड़ा इंपॉर्टेंट है. ठीक है, और इसकी इलस्ट्रेशंस भी इंपॉर्टेंट है. अ सोल्जर फायर्स ऑन अ सुपीरियर्स ऑर्डर ऑन अ मॉब इन कंफर्मिटी विद द लॉ. कि सुपीरियर ने ऑर्डर दिया, सुपीरियर के पास पावर थी ऑर्डर देने की, सोल्जर ने गोली चला दी. he has committed no offense. If the same order of the superior is not in conformity with the law, then he will be liable. Blind disobedience of the superiors will not be a defense. ये सेक्शन नंबर 76 का सूत्रधार है कि अगर आप अपने सुपीरियर के ऑर्डर को आंख बंद करके मान के चल पड़ो और वो ऑर्डर सही नहीं था, तो आपकी रिस्पॉन्सिबिलिटी बनी रहेगी. ठीक है, इसके बाद a very famous maxim that you all people know, that is ignorantia facit excusat, ignorantia juris non excusat. That is, ignorance of fact is an excuse, but ignorance of law is no excuse. ठीक है, अब ये सारी चीजें आपने देखनी है. इलस्ट्रेशंस तो आप करके ही जाएंगे एग्जाम से पहले. सर्टेन केसेस रिलेटेड टू सेक्शन नंबर 76 और वी कैन से मिस्टेक ऑफ फैक्ट से रिलेटेड केसेस हैं. केसेस का नाम लिख लोगे, आई थिंक इट इज मोर देन सफिशिएंट. इससे ज्यादा प्रीलिम्स में नहीं पूछा जाता. Only for your basic understanding, I have mentioned all these cases. That is R versus Levelist. This is one case. R versus Wheat and Stocks, another case on the same kind of a point. फिर इसके बाद एक केस है वरियान सिंह वर्सेस एम्परर का 1926 का लाहौर हाई कोर्ट का. उसमें भी ये सेक्शन नंबर 79 से रिलेटेड है. आप 79 के आसपास इस केस को लिख सकते हैं. दैट इज अ पर्सन इज जस्टिफाइड इन लॉ बाय डूइंग दैट अंडर मिस्टेक ऑफ फैक्ट ही बिलीव्स सो. तो ये कुछ केसेस हैं जो इवेंचुअली पूछे जाते हैं कभी कभी कि इन केसेस में क्या क्या कौन कौन से सेक्शंस जो है वो रिलेटेड हैं. इसके साथ साथ लेट मी टेल यू पीपल व्हाट इज द अदर थिंग्स रिलेवेंट. एक आपको ये पूछा जाता है, इफ अ पर्सन इज बीइंग सिलेक्टेड एज अ जुडिशियल ऑफिसर, व्हाटएवर ही इज डूइंग, डू ही इज बाउंड, do he is liable for anything? The answer is no. An act of a judge while he is acting judiciously is protected under section number 77 of the IPC. If he believes in good faith, he has a power to do such particular act. Section number 78 is there कि हैंग्समैन को लेके कभी कभी सवाल आ जाता है कि हैंग्समैन का मतलब जल्लाद. ठीक है, कि अगर कोई भी व्यक्ति जो कोर्ट के ऑर्डर को ओबे करते हुए कुछ भी करता है तो उसकी लायबिलिटी नहीं होती है. एनी एक्ट इन परस्यूएंट ऑफ द जजमेंट और ऑर्डर ऑफ द कोर्ट, द पर्सन इज नॉट लायबल. सो हैंग्समैन आर प्रोटेक्टेड अंडर सेक्शन नंबर 78. Thereafter, another section, that is, if any person has done something under a mistake of fact and he believes himself to be justified by law, in good faith he is having such belief, so he should not be made liable for such act. ये section number 79 के अंदर है. कुछ एक cases section 79 से कभी कभी पूछ लिए जाते हैं. So state of Odisha versus खोरा घासी is there related with section number 79. कि the person was there in a field, he find that okay there is some एनिमल इन द फील्ड, है ना, तो उसको लगा कि ये एनिमल जो है फील्ड को डिस्ट्रॉय करेगा. ही shot an arrow over the particular object, but it ultimately resulted into the death of the person. So the person find that okay, I was justified in doing this, and the court granted him the benefit of section number 79. Another case related to section number 79, that is Keso Sahu versus Saligram Shah, 1977 Odisha High Court is there. The case is related to the smuggling of the rice. A person stopped the offender, and then he stated that you had wrongfully detained me, wrongfully restrained in there. So he stated that no, whatever I have done, it is done in good faith, and I am justified in doing so. So such kind of cases are there. I hope in the conceptual classes you people have gone through with all of these cases in detail. ये तो रैपिड रिवीजन राउंड है, तो रैपिड रिवीजन में तो फटाफट आपको ये देखना है कि सेक्शंस में क्या क्या है और आपसे कुछ छूट ना जाए बस. ठीक है, अनदर इंपॉर्टेंट केस दैट इज स्टेट ऑफ उड़ीसा वर्सेस राम बहादुर थापा 1960, अगेन ऑफ उड़ीसा हाई कोर्ट. ये थापा जी हैं, नेपाली चौकीदार. ठीक है, सो व्हाट ही डिड, अपने मालिक के साथ कहीं बाहर गया तो इसको लगा कि इनके ऊपर अटैक होगा. ही फ्रॉम हिज खुखरी, है ना, द नेपाली सर्वेंट हैविंग अ वेपन, so from his cookery he attacked over the object, but ultimately it resulted into the death of the person. So the court granted him benefit because whatever he has done, it was done in good faith. So section number 76 is about the legal compulsion and 79 is about the legal justification. There is a basic difference between the two. Section number 80 है accident and misfortune को लेके. So if anything is done as an accident or if any misfortunate event happens, then a person will not be liable for that. That is accident while doing a lawful act in a lawful manner by lawful means without any criminal intention or knowledge, and there is a proper caution, care and caution, and there is an impulsive action. तो अगर आपने बहुत ही तुरंत एक एक्शन आपको लेना पड़ा, whatever you were doing, it was lawful by lawful means, lawful manner, you have no criminal intention or knowledge, you should not be liable for the act you have done. तो इसमें कुछ एक चीजें जो पूछी जाती हैं, you just see the area which I will be marking, that is this one, that A is working with a hatchet, a head flies off and kills a man who is standing by. Here, if there is no want of proper care and caution, अगर कोई जरूरत नहीं थी बहुत ज्यादा सावधानी रखने की, फिर भी वहां पे किसी की डेथ हो गई, तो पर्सन शुड नॉट बी लायबल फॉर दैट, ही इज एक्सक्यूज. लेकिन अगर यहाँ पे होता दैट प्रॉपर कॉशन वाज रिक्वायर्ड बट ही हैज नॉट टेकन, तो इसकी लायबिलिटी फिर फिक्स हो जाती. सो उसका आपको ध्यान रखना है. इसके साथ आपका ये सेक्शन नंबर 80 आ जाएगा. 80 तो चलो मैं कर ही लिया. 81 के साथ डॉक्ट्रिन ऑफ नेसेसिटी है. Doctrine of necessity is there in section number 81, that is primarily associated with different pointers that a person is having a knowledge that okay, whatever he is doing, it will cause the harm to the other person. Act is done without any criminal intention, but it was done in good faith with the purpose of preventing or avoiding some other harm. ठीक है, तो अगर किसी और हार्म को रोकने के लिए आपने गुड फेथ में कोई भी एक्ट किया है, तो आपकी उसको लेके रिस्पॉन्सिबिलिटी नहीं होगी. सेक्शन नंबर 91 सेक्शन नंबर 81 आपको डिफेंस दे देता है. देयर इज अ मैगजीन व्हिच इज कॉल्ड एज क्वाट नेसेसिटीज नॉन हैबिट लीगम, दैट इज वायलेशन ऑफ अ लॉ मे बी एक्सक्यूज्ड बाय नेसेसिटी. Violation of a law may be excused by necessity. Case law is very important on this point, जिसको आप Mignoid case के नाम से जानते हैं. That is R versus Dudley and Stephens, in which the court has stated that okay, self-preservation is no necessity. Self-preservation is no necessity. इसके बाद section number 82, that is anything which is done by a person below the age of 7 years, it is not an offense. It is called as the principle of dolly incapax. Dolly incapax means it refers to the inability to commit a crime because of the lack of understanding and the nature of the act. This is a common law principle. सवाल आ जाता है कि डॉली इनकैपेक्स का प्रिंसिपल कौन सा किसने दिया है, तो इट इज अ कॉमन लॉ प्रिंसिपल. इंग्लैंड की जो कॉमन लॉ की कोर्ट्स हैं उन्होंने ये प्रिंसिपल दिया है. 7 साल से कम उम्र के बच्चे से अगर कोई अपराध हो जाए वो अपराध नहीं माना जाएगा. सेक्शन नंबर 83 which talks about that if a person is under the age of is above the age of 7 and below the age of 12 years and that person is not able to understand or judge the nature and consequences of his conduct, he has not attained sufficient maturity, he will not be liable for the act. But if he is sufficient, if he is able to understand the nature of that, if he is sufficiently matured enough, then he will be liable for that. ठीक है, और इसी के लिए एक मैक्सिम यूज किया जाता है, that is malice makes up for age. ये सेक्शन नंबर 83 के लिए हम यूज करते हैं. malice makes up for age. ओके, कभी कभी आता है कि malice makes up for age, ये कौन से सेक्शन के अंदर आता है, तो ये सेक्शन नंबर 83. सेक्शन नंबर 83 is a rebuttable presumption of law. इसका भी आप ध्यान रखना. सवाल आ जाता है whether it is a rebuttable presumption of law or it is a irrebuttable presumption of law. So it is a rebuttable presumption. Thereafter section number 84 talks about the concept of unsoundness. If any person because of the medical unsoundness is at the time of doing of the act, he is unable to know the nature of the act or whatever he is doing is wrong or contrary to law, such person will be getting the benefit of section number 84, that is the defense of unsoundness. Multiple cases are there on this point. फर्स्ट केस दैट इज आर वर्सेस आर्नोल्ड 1724 का केस है, जिसको वाइल्ड बीस्ट केस के नाम से जाना जाता है. अ पर्सन हु इज अनेबल टू डिस्टिंग्विश बिटवीन गुड एंड इविल, that person will be getting the benefit of such kind of provisions. दूसरा केस है जिसको हेडफील्ड केस के नाम से जाना जाता है. हेडफील्ड केस which is also called as the insane delusion test. Insane delusion test. Thereafter another very very important case इसके ऊपर सेक्शन नंबर 84 आधारित है, जैसे मैकनॉटन्स केस, आर वर्सेस डैनियल मैकनॉटन. लॉर्ड टिंडल ने जजमेंट दिया है. इसके बाद सम इंडियन केसेस आर देयर, दैट इज सुधा करन वर्सेस स्टेट ऑफ केरला 2010, दया भाई छगन भाई ठक्कर वर्सेस स्टेट ऑफ गुजरात 1964, अशीरुद्दीन वर्सेस स्टेट ऑफ वेस्ट बंगाल एंड पापू अलायंस गिजराज सिंह वर्सेस स्टेट ऑफ राजस्थान 2007. ये सारे ही केसेस सेक्शन नंबर 84 से रिलेटेड है, खासकर दया भाई छगन भाई ठक्कर, इट इज अ लैंडमार्क केस। इसमें कोर्ट ने बहुत सारी चीजें बताई हैं और एक ये भी बताया दैट व्हेनेवर यू आर टेकिंग द डिफेंस ऑफ सेक्शन 84 you don't have to prove the things beyond reasonable doubt, you only have to create the preponderance of probabilities। आप सिर्फ प्रोबेबिलिटी क्रिएट कर दो दैट एट द टाइम ऑफ डूइंग अ पर्टिकुलर एक्ट आई वाज नॉट एबल टू अंडरस्टैंड द नेचर ऑफ द एक्ट और आई वाज नॉट एबल टू नो व्हाटएवर आई एम डूइंग इज रॉन्ग और कॉन्ट्रेरी टू लॉ। अगर आप ये भी चीजें बता दें, प्रोबेबिलिटी भी क्रिएट कर दें, यू विल बी गेटिंग द बेनिफिट ऑफ डाउट। आपको बियॉन्ड रीजनेबल डाउट चीजें प्रूव करने की आवश्यकता नहीं है। It was given in the case of Daya Bhai, Chagan Bhai, Thakkar versus State of Gujarat and in the other cases also. Like a person of unsound mind, इसको क्या कहा जाता है? तो this such persons are called as the non-compos mentis. Non-compos mentis का मतलब any person who is idiot, lunatic by illness, medical illness, basically he is not able to know the nature of fact, or disease of delirium tremens. That is, if a person is suffering from a disease of delirium tremens, this disease is because of the continuous drinking of the liquor for many years. There is a disease which is there in the mind, और अगर कोई इस disease से भी affected है तो उसको भी हम unsound ही मानते हैं। एक सवाल आ जाता है कि क्या irresistible impulse इंडिया में डिफेंस है। इररेजिस्टिबल इंपल्स का मतलब होता है बहुत ज्यादा गुस्सा आ जाना। इररेजिस्टिबल इंपल्स का मतलब होता है अप्रतिरोध्य आवेग। अप्रतिरोध्य मतलब जिसको रोका ना जा सके। तो क्या अगर किसी व्यक्ति को बहुत ज्यादा गुस्सा आ गया और उसने कोई एक्ट किया तो क्या ये कंप्लीट डिफेंस है? द आंसर इज नो, इट इज नॉट अ कंप्लीट डिफेंस, नीदर इन इंडिया नॉर इन इंग्लैंड। ठीक है, ना इंडिया में ना इंग्लैंड में। इसके साथ साथ सेक्शन नंबर 85 दैट इज द डिफेंस ऑफ इंटॉक्सिकेशन। इफ द पर्सन बिकॉज ऑफ द इनवॉलंटरी इंटॉक्सिकेशन एट द टाइम ऑफ डूइंग इट ही इज नॉट एबल टू नो द नेचर ऑफ एक्ट और व्हाटएवर ही इज डूइंग इज रॉन्ग और कॉन्ट्ररी टू लॉ, सच पर्सन विल नॉट बी लायबल फॉर दैट पर्टिकुलर एक्ट। Very important case given in this particular section, that is DPP, Directorate of Public Prosecution versus Beard। ये आपका 85 के ऊपर केस करके पूछ लेते हैं। 86 में चलो मेरा आपसे एक सवाल रहेगा, काफी देर से आपसे मैंने सवाल नहीं पूछा। सेक्शन 86 पे कौन सा लैंडमार्क जजमेंट कोर्ट ने दिया है? Honorable Supreme Court has given a very important landmark judgment on section number 86. That is my question to you people, those who are there in the session, Mehak, Anika, Shaktija and Pooja and all, ठीक है, which is the very important case given by the Honorable Supreme Court, decided by the Supreme Court on section number 86 of the IPC। 86 of the IPC कौन बताएगा? Yes, no one। ऐसा मत करो भैया, एग्जाम में पूछा जाएगा। तो फर्स्ट ऑफ ऑल लेट मी टेल यू व्हाट इज देयर इन सेक्शन नंबर 86। देखो, बहुत सारे ऐसे ऑफेंसेस होते हैं जिनको कमिट करने के लिए आपको किसी पर्टिकुलर इंटेंशन या किसी पर्टिकुलर नॉलेज की जरूरत है। मतलब कि बिना मेंजरिया के ऑफेंस हो ही नहीं सकता। ठीक है, बिना मेंजरिया के ऑफेंस हो ही नहीं सकता। सो इफ अ पर्सन वाज अंडर एन इंटॉक्सिकेशन, though it may be a voluntarily intoxication, but that offense cannot be committed without a particular intention or knowledge, and it is specified that offense for which a particular intention or knowledge is required, but because of the intoxication, और ये voluntary intoxication की हम बात करेंगे, because of the intoxication a person cannot frame intention or knowledge। तो जब वो व्यक्ति intoxicated है, बेशक voluntary intoxication है लेकिन intention या knowledge frame नहीं कर सकता, then how we can make that person liable? तो section number 86 एक presumption raise कर लेता है। Presumption is that his liability is to be made on the basis of the knowledge, as knowledge is to be presumed with respect to section number 86 of the IPC। हम मान के चलेंगे कि इस व्यक्ति को जानकारी थी कि इससे कोई अपराध हो सकता है और उसी के बेसिस पे इस व्यक्ति की लाइबिलिटी बन जाएगी। सेक्शन 86 इज द रूल ऑफ एविडेंस। आपने अपने बेरेक पे मार्क करके लिख लेना, इट इज द रूल ऑफ एविडेंस। And the judgments which are important with respect to section number 86, that is R versus Lipman। ये एक जजमेंट है, ये बहुत ज्यादा नहीं पूछा जाता। जो पूछा जाता है वो है बासुदेव वर्सेस स्टेट ऑफ पेप्सू। बासुदेव वर्सेस स्टेट ऑफ पेप्सू, that is Patiala and East Punjab States Union 1956 Supreme Court। This is a very very important judgment on the point of section number 86। इसके बाद आपका सेक्शन नंबर 87 है। 87 इज ऑन द बेसिक पॉइंट that okay, a person is having no intention to cause death or grievous hurt. There is no such criminal knowledge for the causation of death or grievous hurt, and the consent is there of the opposite person with respect to that you can cause any harm to that person, and the person's age is above 18 years. ठीक है, कोई भी व्यक्ति जिसकी उम्र 18 साल से ज्यादा है, उसने खुद कंसेंट दिया कि आप उसको कोई हार्म कॉज कर सकते हो, लेकिन उसकी कोई इंटेंशन ऐसी नहीं है कि आप उसको ग्रीवियस हर्ट या उसकी डेथ कॉज कर दें, तो उसने क्योंकि वो रिस्क खुद उठाया है हार्म उसको होने के लिए, तो सच एक्ट इज एग्जाम्प्टेड अंडर सेक्शन 87। जैसे कि आप मान लो डेंटिस्ट के पास गए, आपने कहा कि दांत बाहर निकाल दीजिए, डेंटिस्ट ने अपना औजार लिए, दांत बाहर निकाले, आपको दर्द होगा, लेकिन डेंटिस्ट की कोई लाइबिलिटी नहीं है, सेक्शन नंबर 87 उनको प्रोटेक्शन दे देगा। नाउ कमिंग टू द नेक्स्ट थिंग, जस्ट गिव मी अ सेकंड। यस, the illustration of section number 87 is important, that A and Z agree to fence with each other for amusement. This agreement implies consent of each other to suffer any harm in which course of fencing may be caused without foul play। ठीक है, A और B दोनों तलवारबाजी कर रहे हैं amusement के लिए, मनोरंजन के लिए, बट इन द कोर्स ऑफ फेंसिंग उनको पता है कि छोटी मोटी कोई इंजरी हो सकती है, कोई फाउल प्ले नहीं है। इफ ए while playing fairly, फेयर प्ले होना जरूरी है, इफ ए व्हाइल प्लेइंग फेयरली हर्ट्स जेड, ए कमिट्स नो ऑफेंस। तो ये चीज का आपको ध्यान रखना है कि कोई अपराध यहाँ पे नहीं माना जाएगा। ठीक है, ये इलस्ट्रेशन यूजुअली पूछी जाती है। देन नेक्स्ट वन इज सेक्शन नंबर 88। A person is having no intention to cause death, but any other harm can be caused for the benefit of such person, and there is a consent express or implied of such person to whom the harm is to be caused, and whatever is done, it is done in good faith, it is with due care and attention. So whatever the person is doing, he is not liable for that। ये सर्जन्स के लिए, डॉक्टर्स के लिए प्रोटेक्शन बना के रखी गई है कि सामने वाले की सर्जरी करनी है, आपको उसके ऊपर कोई उसको हर्ट या ग्रीवियस हर्ट भी शायद कॉज करना पड़े, बट वो गुड फेथ के साथ है ताकि आप उसकी जान बचा पाए। सो व्हाटएवर यू आर डूइंग, इट इज बीइंग परमिटेड एंड एग्जम्प्टेड एज पर सेक्शन नंबर 88। 89 के अंदर आपका जो नेक्स्ट कॉन्सेप्ट है कि अगर किसी 12 साल से कम उम्र के बच्चे के लिए कुछ करना है इन गुड फेथ फॉर सेविंग द लाइफ ऑफ दैट पर्टिकुलर चाइल्ड और दैट अनसाउंड माइंड पर्सन, but you cannot take the consent of such persons, so who will be giving the consent? The consent will be given by the guardian, or the act can be done by the guardian himself। like मान लो अगर एक माइनर बच्चा है, 12 साल से कम उम्र है उसकी मान लो, और उसकी सर्जरी करनी है, तो वो खुद कंसेंट नहीं दे सकता, सो गार्जियन विल बी गिविंग द कंसेंट फॉर दैट, बिकॉज सर्जरी बच्चे के बेनिफिट के लिए है, बट व्हाटएवर इज डन इन गुड फेथ, it is permitted under section number 89, and any harm is caused, you are not liable for that। लेकिन किसने किया ये कंसेंट, किसने दिया? गार्जियन ने। अपार्ट फ्रॉम दैट, अगर गार्जियन खुद ही डॉक्टर हो तो वो खुद भी काम कर सकता है, तो इसीलिए लिखा है द कंसेंट मे बी गिवन बाय द गार्जियन और द एक्ट इज इटसेल्फ डन बाय द गार्जियन हिमसेल्फ। तो दोनों चीजें सेक्शन नंबर 89 के अंदर कवर्ड हैं। सेक्शन नंबर 90 टॉक्स अबाउट व्हेन द कंसेंट इज नॉट वैलिड। तो कोई भी बच्चा जिसकी उम्र 12 साल से कम है, इसको इंपॉर्टेंट है, मार्क कर लेना मेरे में, इफ एनी चाइल्ड हुज एज इज लेस देन द एज ऑफ 12 इयर्स, अगर उसने कंसेंट दिया है वो कंसेंट वैलिड नहीं है। इफ अ पर्सन इज एन इनसेन पर्सन, उसका कंसेंट वैलिड नहीं है। इफ अ पर्सन इज अंडर अ फियर ऑफ और मिसकंसेप्शन and that fear he has given the consent, then also that consent is not considered to be a valid consent। कुछ एक केसेस इसके लिए हैं। एक स्नेक चार्मर का केस बड़ा फेमस, पुणे फतेमा का केस है, जिसमें एक व्यक्ति से आप गलत तरीके से मिसरिप्रेजेंट करके उसका कंसेंट अगर लेंगे एंड देयर बाय यू आर डूइंग एन एक्ट, तो वो कंसेंट वैलिड नहीं माना जाएगा। ठीक है, और कुछ एक केसेस ये रेप से रिलेटेड इश्यूज को लेके आ जाते हैं, दैट इफ अ पर्सन हैज टेकन द कंसेंट अंडर द मिसकंसेप्शन दैट आई विल बी मैरिंग यू एंड देयर आफ्टर यू डोंट मैरी, देन आल्सो दैट इज अ कंसेंट गिवन अंडर मिसकंसेप्शन एंड यू मे बी लायबल फॉर द ऑफेंस ऑफ रेप। तो ये सेक्शन 90 और सेक्शन नंबर 376 का कोरिलेशन है जो कॉन्सेप्चुअल क्लासेस में पढ़ाया जाता है। अभी यहाँ पे तो हम रैपिड रिवीजन में तो सिर्फ ये देख रहे हैं कि कौन कौन से सेक्शंस में क्या क्या चीजें इंपॉर्टेंट है। सेक्शन नंबर 91 वॉलंटरी नॉन फिट इंजूरिया की बात करता है कि अगर आपने कंसेंट दे दिया, सामने वाले ने आपके ऊपर गुड फेथ पे वो एक्ट कंडक्ट किया, तो उसकी कोई लायबिलिटी नहीं है, वॉलंटरी नॉन फिट इंजूरिया। बट अगर कोई इंडिपेंडेंट हार्म कॉज किया जाएगा तो उसके लिए उस व्यक्ति की लायबिलिटी बनी रहेगी। मान लीजिए कि डॉक्टर साहब के पास ये व्यक्ति पहुंचा, हर्ट सर्जरी के लिए डॉक्टर साहब हार्ट सर्जरी करते करते किडनी बाहर निकाल बैठे, तो इट इज एन इंडिपेंडेंट कॉज हार्म कॉज टू सच पर्सन एंड द डॉक्टर विल बी लायबल फॉर दैट। तो जो इसने कंसेंट दिया था कि हार्ट की सर्जरी हो रही है, तो उसके लिए आप इसको ग्रीवियस हर्ट तक कॉज करोगे, उसको चीरा लगाओगे, उसका सर्जरी करोगे, वो एक्सेप्शन में था। लेकिन अगर कोई इंडिपेंडेंट हार्म कॉज कर दोगे, वो एक्सेप्शन में नहीं है। सो सेक्शन 91 की कुछ एक एक्सेप्शंस हैं, दैट इज सेक्शन नंबर 87, 88 एंड 89। ये तीनों सेक्शन 91 के एक्सेप्शंस में आती है। इसके साथ साथ सेक्शन नंबर 92 की कभी कभी ऐसा होता है कि आपको गुड फेथ में कोई एक्ट करना है, लेकिन आपके पास दूसरे व्यक्ति का कंसेंट नहीं है, या कंसेंट लेने का समय नहीं है, या व्यक्ति इनकैपेबल है कंसेंट देने के लिए और गार्जियन अवेलेबल नहीं है, तो सेक्शन नंबर 92 काम करता है। दैट इज देयर इज नो इंटेंशन टू cause death or attempt to cause death. There the purpose is to prevent death, to prevent grievous hurt, to prevent any serious injury, disease or infirmity. Any harm is caused with good faith, without consent, for the benefit of the person. A person is incapable of giving consent and no guardian is there to give the consent. अगर ऐसी कोई सिचुएशन है, जो भी आप करोगे वो आप उसको करने के लिए आपको कोई सजा नहीं मिलेगी। रीजन बीइंग सेक्शन नंबर 92 इज गिविंग यू द प्रोटेक्शन, बट सेक्शन 88, 89 और 92 में लिखी गई कोई भी बात पेक्यूनरी बेनिफिट्स के ऊपर अलाउ नहीं होती है। अगर आप पेक्यूनरी बेनिफिट के लिए कुछ कर रहे हो तो वो यहाँ पे प्रोटेक्शन में नहीं आएगा। इलस्ट्रेशन इंपॉर्टेंट है, ठीक है। इलस्ट्रेशन ऑफ सेक्शन नंबर 92 आर इंपॉर्टेंट, इट यूजुअली कम्स इन द एग्जाम, ठीक है। तो इसको आप ध्यान में रखेंगे। जैसे सेक्शन इलस्ट्रेशन नंबर ए हम कर लेते हैं, चलो। दैट इज इलस्ट्रेशन नंबर ए, दैट इज जेड इज थ्रोन आउट फ्रॉम हिज हॉर्स एंड इज इनसेंसिबल। घोड़े से जेड नीचे गिर गया। एक सर्जन है जो उसकी सर्जरी करेगा, जेड को चीरा लगाना जरूरी है, ट्रिपैन करना जरूरी है, लेकिन A, not intending to cause Z's death in good faith for Z's benefit, performs the trepan before Z recovers his power of judging for himself। कि जब तक उसको होश आता तब तक डॉक्टर साहब ने पूरी इंजरी पूरा ऑपरेशन कर दिया, तो A has committed no offense because whatever is done, it is done in good faith। ठीक है जी। तो इसके बाद सेक्शन नंबर 93, if any communication is made in good faith, you are not liable for any आउटकम ऑफ दैट। सो अगर एक सर्जन ने अपने पेशेंट को कम्युनिकेट किया दैट यू कैन नॉट लिव, बट उसने इसीलिए बताया ताकि पेशेंट अपना कहीं और इलाज करवा ले, तो द पेशेंट डाइज इन कॉन्सिक्वेंस ऑफ द शॉक, सो he has committed no offense though he knew that the communication might cause the patient's death, because ये गुड फेथ में हुआ है तो यू आर नॉट लायबल। लेकिन अगर मैलाफाइड इंटेंशन से करोगे तो यू मे बी लायबल फॉर दैट। सेक्शन नंबर 94, इट इज एक्टस मीन वाइट ऑफ एक्टस, नॉन एस्ट मींस एक्टस। कोई भी एक्ट जो आपने खुद अपनी मर्जी से नहीं किया वो आपका एक्ट नहीं माना जाता। एक्ट ऑफ अ पर्सन अगेंस्ट हिज विल इज नॉट टू बी कंसीडर्ड एज हिज एक्ट। तो यहाँ पे वो अगर कोई भी रॉबरर्स आपके पास आए और कहें कि ताला तोड़ो, और आपने वो ताला तोड़ दिया और आपको जो एप्रीहेंशन दी गई दैट इज द डेथ कैन बी कॉज, सो इन दैट केस व्हाटएवर यू आर डूइंग यू आर नॉट लायबल फॉर दैट। लेकिन देयर आर टू एक्सेप्शंस, दैट यू कैन नॉट कॉज the murder of someone under such threat and you cannot go for an offense against state which is punishable with death। वहां पे ये सेक्शन नंबर 94 का प्रोटेक्शन अवेलेबल नहीं होता है। अपनी मौत और किसी दूसरे की मौत में चुनना पड़े तो सेक्शन 94 कहता है कि अपनी मौत को चुन लो, दूसरे को मत मरवाओ। सेक्शन नंबर 95 इज देयर, दैट इज टॉकिंग अबाउट द कॉन्सेप्ट ऑफ दैट लॉ डज नॉट टेक अकाउंट ऑफ द ट्रिफल्स। छोटे मोटी चीजों का कानून संज्ञान नहीं लेगा। इट इज डी मिनिमिस नॉन क्यूरेट लेक्स, ठीक है। मैक्सिम यूज किया जाता है 95 के लिए, डी मिनिमिस नॉन क्यूरेट लेक्स, दैट इज लॉ डज नॉट टेक अकाउंट ऑफ द ट्रिफल्स। बहुत इंपॉर्टेंट केस था इसमें, विदा मेंगेज वर्सेस यूसुफ खान 1966 सुप्रीम कोर्ट, ठीक है। तो ये सेक्शन नंबर 95 तक के आपके जो जनरल एक्सेप्शन वाला जो एरिया अभी आगे चलेगा प्राइवेट डिफेंस में भी, लेकिन ये सारे सेक्शंस आपको जब भी हमने यहाँ पे किए दीज आर इंपॉर्टेंट। कुछ नई चीजें आपको मिली होगी, नए केसेस मिले होंगे, तो उसको जरूर आप अपनी कॉपी पे बेरेक पे कहीं पे लिख के रख लें। सेक्शन नंबर 96 टॉक्स अबाउट द कॉन्सेप्ट ऑफ प्राइवेट डिफेंस। नथिंग इज डन while exercising private defense is not an offense। ये सिर्फ एक डेक्लारेटरी प्रोविजन है। सवाल आता है कि सेक्शन 96 कैसा प्रोविजन है? डेक्लारेटरी प्रोविजन। नेक्स्ट वन इज सेक्शन नंबर 97 कि प्राइवेट डिफेंस किस चीज के लिए एक्सरसाइज करते हो? तो एक व्यक्ति अपनी जान बचाने के लिए या दूसरे की जान बचाने के लिए, अपनी प्रॉपर्टी बचाने के लिए या दूसरे की प्रॉपर्टी बचाने के लिए, फॉर सेविंग योर ओन प्रॉपर्टी और फॉर सेविंग द प्रॉपर्टी ऑफ सम अदर पर्सन, फॉर सेविंग योर ओन बॉडी और द बॉडी ऑफ अनदर पर्सन, यू कैन एक्सरसाइज द राइट ऑफ प्राइवेट डिफेंस। इसी के साथ साथ इफ द ऑफेंडर is unsound mind, intoxicated, he's doing something under the misconception of fact, if he's because of youth, that is under the age of 7 years, or if he's sufficient mature, that is 7 to 12 years के बीच का भी अगर है, ये भी व्यक्ति अगर कुछ कर रहा है और इसके अगेंस्ट आपको प्राइवेट डिफेंस एक्सरसाइज करना है, you have that competency to go for your private defense against such persons also। बेशक ये लोग जो करेंगे वो पनिशेबल ऑफेंस नहीं होगा, लेकिन फिर भी आप प्राइवेट डिफेंस एक्सरसाइज करने के लिए कंप्लीटली इंटाइटल्ड हो। सेक्शन नंबर 99 रिस्ट्रिक्शंस की बात करता है कि अगर प्राइवेट डिफेंस एक्सरसाइज आपको करना है, लेकिन यू कैन टेक द असिस्टेंस ऑफ द ऑफिशियल अथॉरिटीज, यू शुड नॉट बी गोइंग फॉर एक्सरसाइजिंग ऑफ द प्राइवेट डिफेंस। आप अपनी पावर से एक्सीड नहीं करेंगे। If you are using more power, you are going beyond the private defense, then you will not be getting any benefit of that, rather you will be liable for whatever the act you have done। ठीक है, तो कितना फोर्स अप्लाई करना है वो एक बड़ा इंपॉर्टेंट चीज है। सेक्शन 99 के पैरा नंबर 4 के अंदर वो बताया गया है कि हाउ मच फोर्स यू कैन एक्सरसाइज। Similarly, public servants के against you cannot exercise the private defense unless and until the reasonable apprehension which is being given to you is of grievous hurt or death। ठीक है, तो अगर grievous hurt या death वाली apprehension public servant ने दी है तो you can exercise private defense against such persons also, but otherwise you cannot go for that। Section number 100 कि किन केसेस में आप प्राइवेट डिफेंस एक्सरसाइज करते समय व्यक्ति विशेष की डेथ तक कॉज कर सकते हो। सो देयर आर सर्टेन पॉइंटर्स, दैट इज 7 क्लॉजेस आर देयर इन सेक्शन नंबर 7 इन व्हिच व्हाइल एक्सरसाइजिंग प्राइवेट डिफेंस यू कैन कॉज द डेथ ऑफ द असेलेंट। कि अगर असॉल्ट प्लस रीजनेबल एप्रीहेंशन ऑफ डेथ इज देयर, देन द while exercising private defense you can go to any extent, and even the death of the assailant is there, you are not liable for anything। assault plus reasonable apprehension of grievous hurt, assault plus reasonable apprehension of acid attack, ये तीन चीजों में assault और reasonable apprehension देखा जाता है। reasonable apprehension मतलब only if there is an apprehension and there is an assault you can exercise your private defense, but with respect to the other things there must be assault with intention। तो assault plus intention of rape, assault with intention of natural lust, assault with intention of kidnapping or abduction, और assault with intention of wrongful confinement। अगर ऐसी चीजें आपको मिल जाएं असॉल्ट के साथ इंटेंशन या असॉल्ट के साथ यहाँ पे रीजनेबल एप्रीहेंशन, और आपको लगता है कि ये वाली कोई चीज आपके अगेंस्ट हो सकती है, यू कैन एक्सरसाइज योर प्राइवेट डिफेंस। नाउ सम केसेस ऑन दिस। एक केस है जिसको रॉन्गफुल कन्फाइनमेंट केस के नाम से जाना जाता है, दैट इज विश्वनाथ वर्सेस स्टेट ऑफ यूपी 1960 सुप्रीम कोर्ट, अ वेरी वेरी लैंडमार्क जजमेंट ऑन दिस पॉइंट। इसके बाद सेक्शन नंबर 101 कि इफ द सिनेरियो इज नॉट ऑफ सेक्शन 100 देन यू कैन कॉज एनी अदर हार्म बट यू कैन नॉट कॉज द डेथ ऑफ द पर्सन। व्हेन द राइट टू एक्सरसाइज सेल्फ डिफेंस कंटिन्यूज and when it will stop, so section number 102 is there, the right of private defense commences as soon as the reasonable apprehension is there and it continues as long as the reasonable apprehension continues। जब तक reasonable apprehension रहेगा, खतरा रहेगा, तब तक private defense भी exercise किया जा सकता है। section number 103, that is while exercising the right of private defense the death or any other harm can be caused to the wrongdoer। property से related अगर कोई offense हो रहा था तो आप कब किसी व्यक्ति की जान ले सकते हैं private defense exercise करते समय। so if the offender is doing robbery or dacoity, house breaking by night, mischief by fire, or theft, mischief, or house trespass with the circumstances that reasonable apprehension is there, the grievous hurt will be the consequence। then in such cases 103 states that okay, you can cause the any harm to the wrongdoer, even the death can be caused। section 1074 कह रहा है कि अगर ये वाली situations नहीं है जो 103 की है तो आप death नहीं कर सकते cause, but कोई और अगर harm आपको cause करना है you may go for that। section 105 is there कि राइट आपका कब शुरू होगा, कब खत्म हो जाएगा। तो 4 अलग अलग सिचुएशंस में अलग अलग तरीके की बात रखी गई है। थेफ्ट के केसेस में टिल द ऑफेंडर रिट्रीट और टिल द असिस्टेंस ऑफ द पब्लिक अथॉरिटीज इज ऑब्टेन्ड और टिल द प्रॉपर्टी हैज बीन रिकवर्ड, कभी भी आप जो है अपना प्राइवेट डिफेंस एक्सरसाइज कर सकते हो। रॉबरी के केसेस में व्हेन द रॉन्गडूअर अटेम्प्ट्स टू कॉज द डेथ, हर्ट और रॉन्गफुल रिस्ट्रेन और गिव्स एनी फियर ऑफ इंस्टेंट डेथ और हर्ट और रॉन्गफुल रिस्ट्रेन, तो उन केसेस में आप जब तक ये फियर रहेगा, जब तक रॉन्गडूअर ये कर रहा है, आप प्राइवेट डिफेंस एक्सरसाइज कर सकते हैं। criminal trespass or mischief, till the time offender continues the commission you can go for exercising of the private defense। house breaking by night के cases में as long as the house trespass is there you can go for the exercising of private defense. Section 106, last section with respect to the general exceptions, that talks about that if while exercising the private defense you have to take a risk of the life of the innocent person, you can go for that risk also. कि अगर life threat था, life threat है, if there is a life threat to a person and for exercising private defense he has to take the risk of the life of innocent, ठीक है, तो वहां पे आप वो रिस्क उठा सकते हो, सेक्शन 106 आपको अलाउ करता है. सो द राइट ऑफ प्राइवेट डिफेंस इन इंडिया इज वेरी वाइडर देन द लॉ गिवन इन इंग्लैंड. कुछ एक केसेस हैं जो प्राइवेट डिफेंस से रिलेटेड हैं, दैट इज जयदेव वर्सेस स्टेट, काशीराम वर्सेस स्टेट ऑफ राजस्थान, कश्मीरी लाल वर्सेस स्टेट ऑफ पंजाब, अमजद वर्सेस स्टेट एंड स्टेट ऑफ यूपी वर्सेस रामस्वरूप. ये दो थोड़ी सी इंपॉर्टेंट जजमेंट्स हैं, ठीक है. ये थोड़ी पूछ ली जाती है कि अमजद वर्सेस स्टेट इज रिलेटेड टू व्हिच प्रोविजन ऑफ आईपीसी, सो इट इज रिलेटेड विद द कांसेप्ट ऑफ प्राइवेट डिफेंस. प्राइवेट डिफेंस, ठीक है. रीजनेबल एप्रीहेंशन जैसे ही शुरू होगा, यू कैन एक्सरसाइज योर प्राइवेट डिफेंस. दिस वाज द पॉइंट गिवन बाय द ऑनरेबल सुप्रीम कोर्ट इन अमजद वर्सेस स्टेट, ठीक है. स्टेट ऑफ यूपी वर्सेस रामस्वरूप में कहा गया था देयर कैन नॉट बी अ प्राइवेट डिफेंस अगेंस्ट प्राइवेट डिफेंस, कि अगर आप खुद ही प्राइवेट डिफेंस एक्सरसाइज कर रहे हो और सामने वाला भी ये प्राइवेट डिफेंस एक्सरसाइज करना शुरू कर दे तो ये नहीं चलेगा, ठीक है. एग्रेसर के अगेंस्ट प्राइवेट डिफेंस होता है, प्राइवेट डिफेंस के अगेंस्ट प्राइवेट डिफेंस नहीं होता, ठीक है. तो ये कुछ एक चीजें हैं जो आपको ध्यान में रखनी है. बाय नेक्स्ट अभी हम अबेटमेंट वाला एरिया भी आज क्लोज कर लेते हैं. देखो अबेटमेंट में सेक्शन 107 टिल सेक्शन नंबर 120 इज देयर, in which firstly section 107 is saying that what are the three modes of abatement. Three modes are there: by instigation, by conspiracy, by intentional aiding. तीन तरीके से जो है अबेटमेंट किया जा सकता है. इंस्टिगेशन से मतलब कि टू प्रोवोकिंग, बाय प्रोवोकिंग समवन. कॉन्स्पिरेसी मींस यू कॉन्स्पायर्ड विद समवन एंड देन यू एंगेज समवन टू मेक अ टू कमिट अ पर्टिकुलर ऑफेंस. And thereafter the third is by intentional aiding. So intentional aiding means you are giving an intentional aid to the other person with the purpose that the concerned outcome should be achieved, and that is why you had facilitated the aid to that particular person. एक important case है जो पूछा जाता है यहाँ पे, that is Emperor versus फयाज हुसैन, जिसमें एक व्यक्ति ने पुलिस ऑफिसर्स को अपना प्रॉपर्टी दिया जहां पे पुलिस ऑफिसर टॉर्चर कमिट करते थे. तो वहां पे जो ए नाम का व्यक्ति जिसकी वो प्रॉपर्टी थी, ही वाज लायबल फॉर द ऑफेंस ऑफ अबेटमेंट, ठीक है. तो ये यहाँ से 107 से तो ये पूछ लिया जाता है कि what are the types of abatement. So you must be very aware of these three things, that is instigation, conspiracy and intentional aiding. Intentional aiding वाले सिचुएशन में बस एक चीज इंपॉर्टेंट है, that is the thing for which the abatement is done, that offense has been committed, ठीक है. वो offense फाइनल कमीशन अगर उसका हुआ है तो फिर हम इंटेंशनल एडिंग के अंदर लायबल करते हैं. अदरवाइज इट ओनली बी कॉल्ड टू बी द अटेम्प्ट ऑफ अबेटमेंट, ठीक है. कि जैसे ए ने बी को अबेट किया दैट काइंडली किल सी, और अभी इट इज बेसिकली एन इंस्टिगेशन व्हिच इज गिवन, तो वो इंस्टिगेशन में चला गया. अनदर एग्जांपल इज लाइक ए इज अ पर्सन हु इज looking forward for a weapon to kill B, and you are sitting over here, you supplied weapon to this person, and because of the help of that weapon this person committed the murder of B. So here it is no instigation, but yes, there is intentional aiding, and if there is the intentional aiding you will be liable for the offense of abetment, provided whatever the help you have provided to the other person, because of that help the other person had committed the ultimate offense. तो वो उसका intentional aiding के लिए explanation साथ में चलता है, उसको आपको ध्यान में रखना है. 108 talks about that who is an abettor. So abettor is a person who is abetting the other person, and what is important in this particular section, that is the illustrations. It is not required that the offense which you had abetted is finally committed, because abetment is itself a substantive offense. You are liable for the offense of abetment. आपने क्योंकि abetment किया, आप अबेटमेंट के लिए लायबल हो. सामने वाले ने ऑफेंस किया नहीं किया, दैट इज नॉट मटेरियल. इलस्ट्रेशंस को ध्यान में रखेंगे. इलस्ट्रेशन नंबर ए एंड बी, दैट ए instigates B to murder C, B refuses to do so, but A is still guilty of abetting B to commit murder. अब उसकी सजा क्या होगी, that is altogether different thing. So with respect to the punishment, 109, 114, 115, ये तीन सेक्शंस आपके लिए इंपॉर्टेंट होते हैं कि अबेटमेंट में पनिशमेंट्स कैसे पता की जाती हैं. सो if the other person is not doing any offense to whom you have abetted, still the abettor is liable for that. या जो कॉन्सिक्वेंस आप चाहते थे वो नहीं मिला, फिर भी आपकी लाइबिलिटी उसी चीज के लिए होगी जो आपने बेट किया था। लाइक इलस्ट्रेशन नंबर बी इज देयर, ए इंस्टिगेट्स बी टू कमिट मर्डर, डी बी इन परसुएंस ऑफ इंस्टिगेशन स्टैब्स डी, उसने चाकू मारा, लेकिन डी रिकवर्स फ्रॉम द वाउंड, वो रिकवरी कर गया। तो ए की लाइबिलिटी बी अबेटमेंट टू कमिट मर्डर के लिए ही रहेगी, लेकिन उसकी पनिशमेंट जो है वो सेक्शन नंबर 115 के अंदर चली जाएगी। तो वो एक अलग पैरामीटर है कि कौन से सेक्शन के अंदर आपका पनिशमेंट जा रहा है। लाइबिलिटी क्या होगी वो एक अलग विषय है, पनिशमेंट क्या होगी वो एक अलग विषय है। तो इसको थोड़ा सा आप ध्यान में रखना। कॉन्सेप्चुअल क्लासेस में आपने आई बिलीव किया होगा और कॉपीज के अंदर ये सारी चीजें आपने लिखी होगी कि अबेटमेंट के केसेस में पनिशमेंट कैसे आइडेंटिफाई किया जाता है। एक्सप्लेनेशन नंबर 3 कि जिस व्यक्ति को आपने अबेट किया शायद वो व्यक्ति कैपेबल बाय लॉ नहीं है ऑफेंस करने के लिए, फिर भी आपकी लाइबिलिटी बनी रहेगी। लाइक एज इट इज स्टेटेड इन इलस्ट्रेशन नंबर ए दैट ए विद गिल्टी इंटेंशन अबेट्स अ चाइल्ड or a lunatic to commit an act which would be an offense if committed by a person capable by law to commit an offense। कि एक व्यक्ति को जो चाइल्ड है या लुनाटिक है उसको अबेट किया गया, तो चाइल्ड या लुनाटिक जो कर रहा है वो उसके लिए शायद लायबल ना हो, लेकिन ए की लाइबिलिटी अबेटमेंट के लिए बरकरार रहेगी। ए वेदर द एक्ट इज कमिटेड और नॉट इज लायबल फॉर द ऑफेंस ऑफ अबेटमेंट। ठीक है, तो ये इलस्ट्रेशन आपको ध्यान में रखनी है। इसके बाद एक्सप्लेनेशन नंबर 4 डायरेक्टली पूछा जाता है दैट अबेटमेंट ऑफ एन अबेटमेंट इज आल्सो एन ऑफेंस। कि ए ने बी को अबेट किया कि तुम सी को अबेट करो, कि डी आगे जाके कुछ करेगा, तो ए ने बी को अबेट किया, बी ने आगे सी को अबेट किया, दोनों ए और बी अबेटमेंट के लिए लायबल रहेंगे। ठीक है, एक्सप्लेनेशन नंबर 5 कॉन्स्पिरेसी की बात करता है कि अगर कॉन्स्पिरेसी है और देयर आर टू और मोर पर्संस दे हैव कंस्पायर्ड टुगेदर देन दे एंगेज समवन एंड दे अबेटेड समवन टू कमिट एन ऑफेंस, तो जितने भी लोग कॉन्स्पिरेसी में एंगेज थे सारे ही लायबल रहेंगे ऑफेंस के लिए। Thereafter 109 कि अगर जो ऑफेंस आपने अबेट किया तो वो ऑफेंस फाइनली कमिट हो जाता है, सो यू विल बी लायबल फॉर द ऑफेंस एज द मेन पनिशमेंट इज गिवन फॉर दैट पर्टिकुलर ऑफेंस। तो जो मेन ऑफेंडर को सजा होगी वही अबेटर को सजा होगी, ये सेक्शन नंबर 109 कहता है। 114 में आओ आप लोग। 114 के अंदर डॉक्ट्राइन ऑफ कंस्ट्रक्टिव लायबिलिटी मिल जाती है। व्हाट इज द डॉक्ट्राइन ऑफ कंस्ट्रक्टिव लायबिलिटी? दैट ए अबेट्स बी टू कमिट द मर्डर ऑफ एक्स। ये अबेटमेंट हुआ, देयर आफ्टर ए एंड बी सेपरेटेड। जब बी एक्स का मर्डर करने के लिए गया तो ए वाज प्रेजेंट ऑन द स्पॉट। जब ऐसी सिचुएशन मिल जाएगी तो सेक्शन नंबर 114 अप्लाई हो जाता है, बिकॉज इन सच काइंड ऑफ केसेस ए अपीयर्स टू बी मोर प्रोएक्टिव and here B as well as A both are liable for the same punishment। A माना जाएगा कि उसने खुद ही अपराध किया है, बेशक उसने खुद कुछ नहीं किया। एंड दिस इज वेयर द प्रिंसिपल ऑफ कंस्ट्रक्टिव लायबिलिटी एंड रूल ऑफ एविडेंस ऑफ सेक्शन नंबर 114 इज गोइंग टू बी अप्लाई। इसके बाद सेक्शन 115 है कि इफ अ पर्सन हैज अबेटेड द अदर टू commit an offense which is punishable with death or life imprisonment, but the main offense has not been committed, तो अबेटर की लाइबिलिटी क्या रहेगी? अबेटर की लाइबिलिटी रहेगी 7 इयर्स तक की। कि ए ने बी को अबेट किया कि तुम मर्डर करो, अगर बी कुछ भी नहीं करता तब भी ए की लाइबिलिटी 7 इयर्स तक के लिए है, और अगर बी ने मर्डर करते समय कोई इंजरी कॉज कर दी विक्टिम को तो ए की अबेटर की लाइबिलिटी 14 इयर्स तक एक्सटेंड हो सकती है। ठीक है, और 116 बाकी ऑफेंसेस की बात कर रहा है। 115 बात करता है ऑफेंसेस व्हिच आर पनिशेबल विद डेथ और लाइफ इंप्रिजनमेंट। ऐसा ऑफेंस करने के लिए आपने अबेटमेंट किया था, तो 115 रिमेनिंग ऑफ द ऑफेंसेस के लिए 116 अप्लाई करता है, जिसमें अगर किसी भी व्यक्ति ने अबेटमेंट किया तो उसको अगर सामने वाले ने ऑफेंस नहीं भी किया तो भी अबेटर की एबिलिटी क्या होगी? तो 1/4 का प्रिंसिपल है, पब्लिक सर्वेंट को अबेट करोगे या पब्लिक सर्वेंट अबेट कर रहा है तो 1/2 रहेगा, और अगर कोई दूसरे व्यक्ति को आप अबेट कर रहे हो जो पब्लिक सर्वेंट नहीं है तो 1/4 पनिशमेंट होती है। सो दिस इज द बेसिक थिंग्स द अबेटमेंट इज concerned। 117 not that much relevant with your exam point of view। 118 का एक्सटेंशन जो है वो आप जरूर कर लेंगे। 118 और 19 के थ्रू अगर इलस्ट्रेशन आपको मिल जाती है उनको जरूर फोकस करें। बाकी रिमेनिंग थिंग्स एज फार एज द अबेटमेंट इज कंसर्न्ड वो आई थिंक मोर देन सफिशिएंट है। व्हाट काइंड ऑफ क्वेश्चंस कैन बी देयर? What kind of questions can be there? Just give me 1 second. Yeah, so questions usually examiner used to ask from section number 2 till सेक्शन नंबर 4, यहां से सवाल जनरली पूछे जाते हैं जो एक्स्ट्रा टेरिटोरियल इंट्रा टेरिटोरियल ऑपरेशन से है। Thereafter definitions part में सेक्शन नंबर 6, सेक्शन नंबर 19, सेक्शन नंबर 21, यहाँ से ज्यादा सवाल पूछे जाते हैं। Thereafter सेक्शन नंबर 22 से लेके सेक्शन नंबर 30 तक रैंडम एरियाज में पूछे जाते हैं। मोर फोकस इज ऑन द रॉन्गफुल गेन, रॉन्गफुल लॉस, डिसऑनेस्टली, फ्रॉडुलेंटली, वहां से ज्यादा सवाल पूछे जाते हैं। Thereafter section number 34 onwards, section number 75, all the sections are important with respect to the multiple choice question। 76 से लेके 106 तक भी the case laws as well as the Berek based questions are usually there। और abatement से related जहां तक सवाल है तो 107, 108, 114 जिसमें कंस्ट्रक्टिव लायबिलिटी की बात है, 115 और 116 में पनिशमेंट से रिलेटेड कुछ सवाल अगर आ जाए तो कोई बहुत बड़ी बात नहीं है। ठीक है, तो इनका आपको भी ध्यान रखना है। ठीक है, दैट व्हाटएवर वी हैव डन इन द टुडेज सेशन, यू जस्ट हैव टू टेक केयर कि यहां से ये वाले एरियाज में से सवाल आता है। बाकी आफ्टर दिस द नेक्स्ट एरिया ऑफ डिस्कशन विल बी क्रिमिनल कॉन्स्पिरेसी 120 कैपिटल ए एंड 120 कैपिटल बी। क्रिमिनल कॉन्स्पिरेसी मींस व्हाट, दैट इफ एनी पर्सन had made an agreement with the other to commit an offense or anything which is prohibited by law or anything which creates a ground for civil action, मतलब कोई भी illegal काम करने के लिए अगर आपने कोई conspiracy किया, you are liable for that। The punishment for criminal conspiracy is given in section number 120 capital B कि if the offense is there for which the conspiracy is there between the persons, you are liable with respect to the punishment which is provided for that offense only। But बाकी cases में it can be 6 months to the maximum imprisonment which can be given। 120B के अंदर ये पूरा punishment का तरीका है कि you are liable as if you are an abettor। ये 120B ऐसे शुरू होता है, that punishment of the conspirators is as if they are the abettors। तो जैसे abetment की punishment है वैसे ही conspirators की punishment रहती है। But if the conspiracy is to commit any act which is prohibited by law or which creates a ground for civil action, तो उन केसेस में जो सजा है या फिर वो ऑफेंसेस जिनकी सजा 2 साल से कम की होती है, ऐसे ऑफेंस को करने के लिए अगर क्रिमिनल कॉन्स्पिरेसी किया गया है तो योर पनिशमेंट कैन बी टू द मैक्सिमम ऑफ 6 मंथ्स और विद फाइन और विद बोथ। तो वो थोड़ा सा आपको 120B के अंदर जो पनिशमेंट का क्राइटेरिया है उसका थोड़ा सा ध्यान रखना है। बाकी रिमेनिंग एज फार एज द बेयर एक्ट इज कंसर्न्ड इतना ही आपको फोकस करना होता है। बाकी जो मैंने स्टार्टिंग में आप लोगों को चीजें बताई कि ये जो बेसिक इंट्रोडक्टरी पोर्शंस हैं कि किसने बनाया आईपीसी, थॉमस बेबिंगटन मैकॉले, कौन कौन मेंबर्स थे आपके चेयरमैन इस कमीशन में, फर्स्ट लॉ कमीशन में, तो उनका आपको नाम याद रखना है। कब इसकी इन्फोर्समेंट हुई है, दैट इज 1 जनवरी 1862। कितने चैप्टर्स हैं, कितने सेक्शंस हैं, 23 चैप्टर्स, 511 सेक्शंस, इसका ध्यान रखना है। फ्रॉम वेयर वी ड्रॉ द कॉन्स्टिट्यूशनल वैलिडिटी, आर्टिकल 13 क्लॉज 1 एंड आर्टिकल 372, इनका आपको ध्यान रखना है। डेफिनेशन डीजीएस में इतना ज्यादा नहीं पूछी जाती है, बट फिर भी टू सम एक्सटेंट वी हैड डिस्कस्ड। अपार्ट फ्रॉम दैट फिर उसके बाद ये जो केसेस मैंने बताए थे, केसेस का थोड़ा सा खास ध्यान रखना बिकॉज डायरेक्टली दे यूज्ड टू पुट अप सच क्वेश्चंस इन द एग्जाम। बाकी द रेस्ट ऑफ द थिंग्स वी विल बी टेकिंग अप इन द नेक्स्ट सेशन बाय टुमारो। आज का सेशन यहीं पे समाप्त होता है। थैंक यू सो मच। कल की क्लास में वी विल बी टेकिंग अप द नेक्स्ट एरिया ऑफ डिस्कशन ऑनवर्ड सेक्शन नंबर 141, क्योंकि 140 तक का जो एरिया है वो बहुत एक ऑफ बीट एरिया, वहां से सवाल जनरली नहीं आते हैं। 141 onwards the remaining area will be there, that we will be discussing in the tomorrow session। Thank you so much to all, we'll meet tomorrow and we'll be having the further discussion on IPC। Thank you so much।